Weekly list, item number 1.
Mr. Das,
Well.
last time you gave reply to the submission regarding this delay in lodging the FIR. Whatever you have stated, we have noted a little. Your submission was that he is a tribal guy, PW1, and is it about 22 years, and it was a small village, only 25 persons were there, and she had seen before her eyes what had happened, and threat was given to her, and she was having two brothers, and the threat was given to the extent that if you divulge it to anybody, then the brothers would be. So in the FIR even she has stated that mu luchi kari asi ettala dauchi. So that was the state of mind of that girl after the occurrence, and therefore it cannot be said that there was inordinate delay in lodging the FIR, or on the ground of delay or evidence should be discarded. That we have noted down. So you continue whatever you want.
So for the delay the
unmute ଆମେ ଯୋଉ ଆପଣ କହୁଛୁ ଆପଣ ଶୁଣି ପାରୁଛନ୍ତି ତ? ନାଇଁ, ଆମେ ଆପଣଙ୍କ କଥା ଶୁଣି ପାରୁନୁ। ଆଚ୍ଛା, ଏମାନେ ଯୋଉମାନେ ଛିଡା ହେଇଛନ୍ତି ସେମାନଙ୍କୁ ବି ଶୁଭା ଯାଉଛି? ଆଚ୍ଛା, ଗତ ସପ୍ତାହରେ ଯୋଉ ଓକିଲ ବାବୁ ମାନେ ଆର୍ଗୁମେଣ୍ଟ କରୁଥିଲେ, 2 ଜଣ ଓକିଲ ବାବୁ ସେମାନଙ୍କ ପାଇଁ, ତ ଯାହା ଏଠି ଚାଲିଛି ଆପଣ ଆର୍ଗୁମେଣ୍ଟ ତାଙ୍କୁ ଟିକେ ବୁଝେଇ ଦେଇଛନ୍ତି ତ? ଆଚ୍ଛା, ସେ ଯାହା ଆଉ କିଛି ଯଦି ପଚାରିବାକୁ ଚାହିଁବେ ବା କହିବାକୁ ଚାହିଁବେ, ଆପଣ ତାଙ୍କର ଆଡଭୋକେଟଙ୍କ ସାଙ୍ଗରେ ଜଣେଇଦେବେ ସେ ବିଷୟରେ, ହେଲା? ଯଦି କୌଣସି ଇନଫର୍ମେସନ ଆପଣ ସେୟାର କରିବାକୁ ଚାହିଁବେ। ତା ଛଡା ଆମେ ଗୋଟେ ଅର୍ଡରଟେ ପାସ୍ କରିଛୁ ଲାଷ୍ଟ ଡେଟରେ, ଯେ ସେଟା ଫାଶୀ କେସରେ ଏସବୁ ଶୁଣାଣି ବେଳେ ଏସବୁ ଅର୍ଡର ପାସ୍ କରିବାକୁ ଅନରେବୁଲ ସୁପ୍ରିମ କୋର୍ଟ କହିଥିଲେ, ଯୋଉ ବିଭିନ୍ନ ଆଙ୍ଗେଲରୁ ଆମେ ସେ ରିପୋର୍ଟଟା ମଗେଇଛୁ, ଯେ ସେମାନଙ୍କର ବ୍ୟବହାର, ସେମାନଙ୍କର କେମିତି ଥିଲା ଏ ଘଟଣା ପୂର୍ବରୁ, ତାଙ୍କ ନାଁରେ କିଛି କେସବାସ ଥିଲା କି ନାହିଁ, ଆଉ ଜେଲରୁ ଆସିବା ପରଠୁ ତାଙ୍କର ଆଚରଣ କଣ ଅଛି, ସେ ବିଷୟରେ ଜେଲ ସୁପରିଟେଣ୍ଡେଣ୍ଟ ରିପୋର୍ଟ ଦେବେ। ବାକି ପ୍ରୋବେସନ ଅଫିସର ଜଣେ ସିଏ ଯାଇକିନି ସେଠୁ ବୁଝାବୁଝି କରିବେ, ତାଙ୍କର ଗାଁରେ ସବୁ ଏନକ୍ୱାରି କରିବେ, ସେ ବିଷୟରେ ରିପୋର୍ଟ ଦେବେ, ଏବଂ ମେଡିକାଲ ଅଫିସର୍ସ ମଧ୍ୟ ସିଏ ରିପୋର୍ଟ ଦେବେ। ଏବଂ ତା ଛଡା ସେ ଅର୍ଡରରେ କୁହାଯାଇଛି ଯେ ସେମାନେ ଯଦି କୌଣସି ସତ୍ୟ ପାଠ ଦବାକୁ ଚାହାନ୍ତି ମଧ୍ୟ ସେ ବିଷୟରେ ମଧ୍ୟ ଦେଇପାରିବେ। ତେଣୁ ଏଇଟା ଗୋଟେ ଫାଶୀ କେସର ଶୁଣାଣିରେ ଏଇଟା ଗୋଟେ procedure follow ହବାକୁ ଦରକାର ତେଣୁ ସେଥିପାଇଁ ଆପଣ ତାଙ୍କୁ ବୁଝେଇ ଦିଅନ୍ତୁ ସେ order ଟା ମଧ୍ୟ ବୋଧେ Mr. Chan and you both of you perhaps you are aware that an order has been passed. Mr. Das, so that order has been passed.
I'll comment.
You communicate and because we have given I think third is the last date, so you have to collect those information and any affidavit you want to just file, you file it by. So that is just a routine manner is to be done. So ବର୍ତ୍ତମାନ ଆମେ ଏ ଆଜିର ଯୋଉ ଶୁଣାଣି ଆରମ୍ଭ କରୁଛୁ ଆପଣ ମାନେ ଶୁଣନ୍ତୁ ତ ଆପଣ ମାନେ ବସି ଯାଆନ୍ତୁ ବସିକିନି ଶୁଣନ୍ତୁ ହେଲା
So far the delay is concerned, my lord, I have already
please adjust your mic little so that clear.
The delay is concerned, my lord, I have already submitted. So for another thing, only addition, my lord, the delay. That the delay has been.
ଏଟାକୁ ଅଫ୍ କରିଦିଅ ଭିଡିଓଟା ବି ଦରକାର ନାହିଁ ସେମାନେ କିନ୍ତୁ ଦେଖିପାରୁଥିବେ ହେଲା ଠିକ ଅଛି yes.
So when the delay is possibly explained and satisfactorily explained, so that is not fatal to the prosecution case.
No, they were raising a point, very vital point that you are to answer. That let us say the occurrence took place on 9th evening and 10th on 9th she was taken and stayed in a person's house. Then on 10th a meeting took place, but though it is the prosecution case or evidence that she stayed in the house of PW5 for some days, but the other person has not stated anything like that. So there is no evidence adduced by the prosecution, because according to them it is the duty of the prosecution to prove that some kind of restriction was there, that the accused persons were keeping and watch over the movement of PW1, and that was the reason for which she could not go out of the village to lodge the FIR. So if that evidence is not there, if he was not staying in that person's house, the accused persons were not keeping any watch, so their submission was that she was free, she was moving freely. So in that situation, if she could have come on 16th, why she did not come on 10th or 11th to the police station to lodge the FIR?
Last occasion also I answer to this question, my lord. Now again I will answer, my lord. My lord, the occurrence took place in a village of 25 villages, my lord. Now is a girl, 25 houses, my lord.
25 houses.
25 houses, right? 25 houses. And the tribal girl or lady, my lord, has seen the occurrence in his eyes, what happened there. And thereafter, suppose in 10th also there is a meeting where the threat was given. And there is continuous threatening that if you'll say anything, and the accused persons will be inside the bar, the village people also kill her.
So you mean to say that direct evidence is available so far as threat is concerned, that is in respect of 9th and 10th.
10th, my lord. And then 10th, my lord.
Okay.
So, my lord, thereafter also, my lord will go. The victim and the informer, my lord, the state of mind, the trauma he is going on at that moment, was going on that during that period, and the tension in the society, that particular village, and one girl having lost his parents and sister, and till the date he received the information 15 that they have already cremated the dead bodies. Till that, there may be some hope that they are gone, even though they have told that yes, we have murdered the parents. But the moment he came to know that my parents and sister were born, cremated has been done. Then he got the courage and somehow cooled down in that during period some gap he got to calm and to out of to the trauma and something. So that's why he went to the police station after when he received the information on 15, 16 he lost the affair. So that trauma and the mental condition of the infant to be considered, my lord, that what was at that time of the situation. Once we came to in general principle, my lord, suppose a person died in a house and the dead body is there, unless until the cremation is going is not done, the mind is something different. The after cremation of everything, so that the mind changes, my lord. So where now when he came to know that everything is gone, everything is lost, he lost his parents, his everything, cremation is done. So he went to the police station with the courage that let us lodge a affair.
No, that means what you say, that even though the accused persons told to her on 9th itself that we have murdered your parents, we have murdered your elder sister, still then she was having hope
My lord. The
of
actual
some kind.
Huh.
But that is why she did not go.
he was under pressure, under trauma, under fearness, under threat, everything was there, my lord. Not only this, we should know, presume the visualize the condition, mental condition of the girl who is alone in the village, and the other people also nobody is supporting her at that moment. So that fear psychology is carrying on his mind, my lord.
No, why it suddenly dispersed on
On 15, when he received the information that cremation has been done, so that mind at that moment he got 5 to 10 days, my lord. 9 is 16, suppose
5, 6
5 to
days.
6 days, my lord. So in between, some changes in mind and some courage definitely will come, my lord. And once he got the information that is,
Because the threat perception as such remains.
it remains, my lord.
The accused persons have not been taken
Yes,
to
ma'am.
custody. No FIR
No
has been
FIR, ma'am.
lodged. That the accused persons are available in the village.
And also
So-
in their mind that even though there is no one is watching her, but in her mind, it was there that somebody is watching me because the threat is there. So I cannot go. If I'll go to the police station, somebody will catch me. So that was going on. He was in different thought process will come in that.
But you have just got the explanation.
But
He has just stated that since I was, you can get that line
my lord.
from her evidence.
FIR, my lord.
ସେ ଯୋଉ ଘଟଣା ପରେ ସେ ଯୋଉ ଖାଲି ଗୋଟେ ଦିଟା ଲାଇନ ସେ କହିଛି ବୋଧେ ମୁଁ ଥ୍ରେଟ୍ ଯୋଗୁ ମୁଁ
ସେ କହୁଥିଲା my lord, I'm blessing my lord.
ସେଇ ଯୋଉ FIR
ଖାଲି ଶୁଣିବାକୁ ପାଇଲି ଯେ
ନାଇଁ ଏଭିଡେନ୍ସ କୁ ପଳେଇ ଆସନ୍ତୁ ହଁ you come to paragraph number 5 1 2 3 4 5 6 lines from the bottom.
paragraph, my lord.
Paragraph number 5 page hochi 105 PW1
My lord.
6 lines from the bottom.
My lord. They threatened me
They threatened me
that if I submit a report to the police,
this is the explanation for delayed lodging of the FIR.
lodging the FIR.
Right.
And also in the FIR he has given a
No, it's all right. But
explanation.
just see the evidence what he has stated.
They
Yeah.
threatened me in the meeting that if I submit a report to the police or give evidence in the court, it would not take seconds for them to kill me. And if they would be kept in jail, other villagers would not spare us. Because of their threat, considering danger to my life, I stayed in the house of Dara Singh, PW5.
This is not supported about yes.
And Smriti also and so died, my lord. Then on 15/9/2016, I came to know that the accused person brought out the dead bodies of my parents and sister from the ditch where they had buried the bodies, and they set fire those by pouring kerosene on it on the preceding day. On one ditch was dug by JCB machine for construction of the water tank. Where it was launched, they had buried the bodies. Hearing about those incidents, I went to the police station and reported the matter at the police station. On Jonathan Lima scribed the report to my.
So that is all the explanation.
Yes, ma'am.
That threat was given to me in that meeting, and that is why I was apprehending danger to my life. I could not go to the police station, and I stayed there in that house of so and so. But on 16th, when I came to know that this thing has already happened on 15th, I went to the police station.
Got arrested and went to the police station.
According to Mr. Chand and according to Mr. Das, this explanation is not satisfactory, and that she was when there is no evidence of any kind of restriction of her movement, any kind of watching or movement by the accused persons.
No, there is no watching. It cannot be said by the because there must be the watching, because when the occurrence took place, they are given the threat that you don't if you lodge a FIR. So definitely they are watching only without his knowledge.
It is them to explain.
No, exactly. I am submitting.
The prosecution wish to explain.
My lord, I am submitting that the girl was given threatened in the meeting, also in the occurrence place, and also thereafter the occurrence place, my lord, regarding the to kill her, or to the brothers, my lord. That threaten and the psycho fear and the trauma is going on her mind at that moment, my lord. So that immediately after the occurrence is not get courage to went to the police station to lodge a FIR. He waited till some days when he came in 15 mile, after 4 days or 5 days, he came to know that the parents were the bodies of the parents were lifted out from where it was buried, and cremation was done, my lord. Then the mind state of the informed, my lord, changed, because everything is lost. Everything he lost his parents, and he lost his nothing more to say. So in that moment, he got a courage. No, I will lodge a FIR. And prior to also, my lord, the threat is regarding, my lord. There's also in the cross examination they have brought that the previous incidents were there, where they assaulted the father of the Pedal one, and also there at that moment they also feared to lodge a FIR, my lord. So that pure psychology is was there in the mind of the infant at that moment, my lord. So we cannot say that even if there is no supporting corroboration or other evidence that there is no watch, there is nobody is watching, he was not kept in lock and key. So that is not only, and only that delay is not concerned that how many days back. It also corroborates regarding the evidence which corroborate to the other evidence, madam.
No, you are right in the sense that it depends upon person to person. So suppose threat is given to a particular person, he might not be he will just ignore it. He may have that courage. Somebody may feel apprehensive for some period, but somebody may keep it that for a longer period. So it depends upon that what is the that person's courage, what is how the person in what societies he has been or he has been brought up, and all these things depends. So it cannot be said that within this particular period the fear psychosis would disperse, and what situation also a fear which was there that would disperse, that also depends. Vary from
and circumstances, my lord. Also.
Yeah.
Situations, my lord. So my submission is that the explanation given by the informant and in the FIR also regarding the fearness and due to the threaten, he has lost the FIR after some days, my lord, delay is there. So that is acceptable and satisfactory to that is not fatal to the prosecution case, my lord.
What about these contradictions which has been brought out?
I will go on that. The contradictions I will go. There are two places of occurrence.
Hmm.
One is where inside the cowshed, my lord. Another place is the buried place where the that particular commission was done, my lord. Now that has not been seen. The infant has only seen the occurrence place, first occurrence, my lord. My lord, the FIR, my lord, will go, my lord. My lord, go to the FIR. I already scrutinized, my lord. The FIR and the was lodged on 16th, and the 116th statement also recorded on 16th, my lord. And the FIR and the 161 and 164 also, my lord. The occurrence about the first occurrence is similar, and there is no contradiction. Minor contradictions are there, my lord. Somewhere he has stated that the injection has put in chest. It's not in the FIR or 164. And Kawa is assaulted by the Kawa.
Names of the accused person.
I say everything similar. Everything similar.
FIR 161 and
164, my lord.
Okay.
All are, my lord, that is consistent in the evidence.
Just a minute.
And so far as FIR is concerned, my lord, the FIR is not as encyclopedia, my lord, knows, my lord, that where all the facts should be disclosed, my lord. Now, what he has disclosed about the in the FIR, that is about the occurrence, my lord, first occurrence and the second occurrence, my lord. Now, what he has stated in the 164, after the occurrence and during that period, my lord, meetings were held and all these things, my lord. He has not explained in the FIR. But it is not that the original occurrence which has been seen by him or her, he has changes his time to time. That is consistent, my lord. So far the occurrence place, first occurrence is concerned, my lord. My lord will go through the 161, FIR, 164 and deposition, my lord. In para, we might go to the para 2 of the deposition, my lord.
No, another thing, important thing, this FIR was lost after this so-called meeting took place or not?
Yes, madam.
The meeting took place on 10th. So, where is that find mentioned in that FIR?
FIR has not been mentioned regarding the meeting, madam. It is admitted fact, not mentioned. But that is not that all the things we disclose. Whether the FIR is contents of the FIR is the cognizable offense or not.
No. That is it is, you see, that is a vital part of your prosecution.
Yes, madam. I will come to that. Because why he has disclosed everything in 164? Why not in the 164 FIR and also not in the 161? My lord, FIR he has stated about the occurrence and the threat, my lord, but not about the extrajudicial confession.
FIR he has stated only the part which took place in that cow shed.
And thereafter they took away the one by one.
That is on 9th.
9th.
So from 9 till 16, this meeting took place on 10th.
Yes, madam.
So in the first information report, that is totally not there. So what
the girl of a tribal girl.
You are making a submission that whatever has happened after 9, since he gave the statement after in the 164 statement after 3 to 4 days, this meeting, if this would have been held or after this lodging of the FIR, matter is different.
I will explain, my lord. Because
meeting took place on 10th.
10th, my lord. Then
in the FIR, why
it has not been mentioned, my lord. Yes. My lord, the one girl reported the matter to the police station, and it was scribed by someone. And when the matter was scribed by someone, and the informant is giving the occurrence about the occurrence, my lord. What if the question may be asked by at the time of the scribe, what happened? He must have cleared that this is the happened, this is the occurrence. He may not be asked about what happened thereafter the occurrence.
It was your duty
to
examine the scribe of the FIR.
My lord, that has not been done, my lord. So far, my lord, FIR is concerned, my lord, whether court should be scrutinized whether at the time of the FIR the particular cognizable offense has been made out or not.
No,
And-
that is the general.
My lord, general principle.
ଜଣେ
And here, my lord,
ଇଏ କହୁଛି ଜଣେ ଲେଖୁଛି
my lord,
ଏଇଆ ତ କଥା।
my lord, he has stated that as per my dictation, he has written, my lord.
ଯଦି ଏତଲାରେ ନାହିଁ ଗୋଟେ ଭାଇଟାଲ ପାର୍ଟ, ଯେମିତି ଗୋଟେ ମିଟିଂ ହେଲା, ମିଟିଂ ରେ ସେମାନେ ଦୋଷ ସ୍ୱୀକାର କଲେ, ମିଟିଂ ରେ ସେମାନେ ତାକୁ ଧମକେଇଲେ, ଏଇଟା ହଉଛି ଗୋଟେ ଭାଇଟାଲ ଆସ୍ପେକ୍ଟ, କାରଣ ଦ୍ୟାଟ ଇଜ ୱାନ୍ ଅଫ ଦି ଗ୍ରାଉଣ୍ଡ ଫର ଅଲସୋ ଏକ୍ସପ୍ଲେନିଂ ଦି ଡିଲେଇଂ ଲଜିଂ ଦି ଏଫଆଇଆର।
My lord.
ଏଇ ପାର୍ଟଟା ଯଦି ଆପଣଙ୍କର ଏଫଆଇଆର ରେ ନାହିଁ,
It's not that.
ଆପଣ ଆଡଭାନ୍ସ କରୁଛନ୍ତି ବର୍ତ୍ତମାନ ଆର୍ଗୁମେଣ୍ଟ ଯେ ସେ ଏଫଆଇଆର ତ ଗୋଟେ ଅନ୍ୟ ଲୋକ ଲେଖିଲା, ଇଏ ତ ନିଜେ
ନାଇଁ।
ଲେଖିନି, ତେଣୁ ସିଏ ତାର କଣ ଲେଖିଦେଇଥିବ, ଇଏ
ସେଟା ମୁଁ କହୁଛି। I'm not telling you that କଣ ଲେଖିଦେଇଥିବ, ନାଇଁ। My submission is that the illiterate girl went to the police station to lodge an FIR about the occurrence. He might have been knowing that everything is details will be disclosed before him, that what happened in the meeting, what happened thereafter. When he must be asked by the police officer or the scriber, what happened, what you want to write, what you want to lodge the information. He must have described about the occurrence. No question may not be put to there, or he may not be knowing that what she should tell about the thereafter what happens in the whether the meeting has happened, the threat was given out to her or not. It is required to be disclosed before the scriber. It is not his mind, my lord. Because when the 161, even the 161, he has not stated about that. In 164 statement, it was he recalled, because when
that
he
is exactly they say that it was a concocted version. After 3 days, when you are coming up with such an explanation that a meeting was held, it is their submission that such an statement was introduced for the first time after 3 days of the lodging of the FIR, just to explain that the delay in lodging the
my lord, so far the 162 statement is concerned, my lord. I last occasion I also citing one decision. What is the at the time of recording 164 statement? What is the role of the magistrate, my lord? So he should elicit the witness regarding what he has to state, what were the details he has to say, to blot out from his mouth, my lord. So here, my lord, when there is a gap of time recording of the 164 statement, my lord, after the 3 days of the lodging the FIR, at that moment he recalled everything, and when he went to the court, there was a courage, there was a police escort, he went to the court, and the magistrate there must have elicited her and what to tell, what to disclose, everything. When he explained her, he explained everything, one by one. So that 161 statement is recorded, which is not done by at that time of the 161 statement recorded by the police member. So that 164 and regarding the extrajudicial confession and so far.
Any direct questions has been put to that witness PW1 ଯେ ତମେ ତ ଏତଲାରେ ମିଟିଂ ହେଇଥିଲା ବୋଲି କହିନ, ତମେ ତ 161 ରେ ମିଟିଂ ହେଇଥିଲା ବୋଲି କହିନ, ତମେ ପ୍ରଥମ ଥର ପାଇଁ ଏଇ ଯୋଉ ଜିନିଷଟା
that has not been suggested. A particular
para 40 and 41 of the evidence of the IO.
Very contradiction.
Yes, he has said.
No, not contradiction.
Contradiction.
Have you put a question directly? Because that opportunity you cannot otherwise. IO को आपण जदि delay in recording statement हला, you have to put a pertinent question. जे आपण तो ये ना आपण ये जो साक्षी जेता available थिला कोन पई तांको explain न करिया उदले सी तो कोन सी कार्य वस्तु थिबो अन्य कामरे अन्य केस रे would have explained. तेणु 3 दिन 4 दिन परे मन कर ता पाखरे से 6-5 6टा केस इन्वेस्टिगेशन चार्ज रे नेछि, सब केस से देखुथिबो सेठी गोटे साक्षीटा को एग्जामिन करिया को मन कर 2-3 दिन डेरी हेला, आपण कोनोसी क्वेश्चन पचारले नाही जे बाबू तू डिले कोन पई हेला 2-3 दिन परे साक्षी तो गां रे थिला, तू काई डिले करू, से तो कहि पार था गोटे आईओ एग्जांपल दोची, से कहि था आज्ञा मोर 4टा 5टा 302 केस थिला, मोर सब तदबीर करिया होथिला, तेणु मो सेथि पई सेउडा देखिला को एटा को डेरी हेला, कहि पार था whether that explanation would be acceptable or not acceptable, that is up to the court. सेथि पई आपण এই जो वर्तमान जो submission टा advance करथिले which we have also noted that in the FIR there is nothing about holding of meeting. In 161 there was no holding of meeting. But for the first time in 164, which was recorded 3 days after the lodging of the FIR, she has stated about the meeting being held on 10. So, crux of the matter is whether you put a direct question regarding the delay in disclosure about the meeting in the 164 CRP.
I do consider there is no direct matter, but matter may see page 110. A suggestion has been made to which she denied. Para 19. To that para 19, page 110 matter.
That is contradiction here.
No, contradiction was a question was there, but she denied to that. It is not a fact that the recording suggestion may skip the first 2, 3, 4 lines.
Not stated before.
Yes. Urgently they apprehended that the villagers make
तो पचारजनी सेटा बापू गई आयो जरिया ने
I was at 1446 and there was absolutely no threatening. The first part or the second part is 161 statement also she has not said. I have said that matter story, no direct question was there. But this thing has been come up through the contradiction and which was confronted. I was also supported this statement, this pureness was not stated at the earliest ballot. In the statement which was recorded by the police on 16th. So for the first time again, she has developed this matter. And the ID matter has put a pertinent question that it was contended by my state that she is not jani ki kalchi, but then the endorsement is there that mu कहवा मुताबिक लिखी लिखी पढ़े सुनाई देले ठीक हुआ जानी मु दस्तखत करछि. FIR last part described after the particular it was scribed by the other person my lord. It was also not very exact. Yes. No, I am not saying no. She has said that पढ़ी लिखी जानी जी ठीक अछि that thereafter she
some omission is not a contradiction, my lord. Because the 164 and the deposition, my lord, is also consistent and congruent, man.
Page 18 of the paper book towards last FIR. And my lord score is page 110 para 19.
So you find out decisions
I am
that when no direct question has been put regarding delay in disclosing about this one. So even the IU also same thing. Delay in examination of the witnesses. You must put direct question to the IO that it is the defense duty. Otherwise, it's based on that principle of natural justice. So he can explain
on that.
If he gives an explanation which is not acceptable, the court is different. But you are drawing an inference that the IO has conducted perfunctory investigation. So why? Because an eyewitness was available. She did not examine him on the very far day of occurrence. On the next day, he examined on third day. Let us say for an example. So as we said that he might have been busy in some other cases. He might be busy in some law and order situation, whatever it may be. So thereby, the delay might have been. So it's just give an opportunity to ask him that why you did not so and so. So otherwise, it is be taking just behind his back. You just take against him, against his conduct. So, so no direct question has been put to the. Okay. Anything further about their contentions raised? They first of all, this delay. Then they said that the evidence of PW1 that she was staying in the house of PW5. There is no corroboration. Even PW5 has not stated in the 161 statement also that PW1 was staying in my house.
Staying in his house or anywhere in the village is not a matter that people, the occurrence took place and the evidence of the deposition given by the
No.
that will be discarded
What you
where
say
he
that
was
it
staying.
does not matter.
Matter.
If he is staying in somebody's house, that is her evidence.
Not confined by the own.
It's all our own. But that man is not supporting or not telling anything.
Obvious matter because the
Okay, all right. Then where she was staying? If she was not staying in anybody's house, she was not staying on her own house.
Because my lord,
Their contention was she was moving freely.
yes, he was moving free. There is no prosecution case is not that he was confined.
No physical restraint.
No physical
No
restraint.
one was keeping
Only the threaten and the fear.
No one was keeping eyes on her.
Yes,
There is no evidence.
no evidence, madam.
So only threat.
Only the threat and the fear cycles, madam.
Oh.
And the mental condition of the informant at that moment, my lord. The trauma is going on inside the.
No, that we have noted.
Right.
Yes.
And so far is, my lord, the statement, the deposition is concerned and 164 statement is concerned, my lord. Some omission was there in the FIR and 161 which has been stated in the, my lord, 164 and the deposition which is similar, my lord. This improvement, the omission or improvement is not a contradiction to the, as per the settled principle, my lord.
Unless materials
is now the some discrepancies are there. There is very minor in the.
Okay, you mean to say that the contradictions which have been proved,
my lord.
those are minor contradictions.
Contradiction.
It does not go to the root of the matter.
Root of the matter, my lord. And when the evidence is
who was practicing witchcraft out of the three deceased?
Here's allegation against the that as per the they're asking to the father of the victim manager informant that he was doing and this supported by the mother and the sister.
Then why they killed the sister, elder sister?
Sister was assisting by the sister mother.
No, there is no evidence.
They have what they have in the statement, my lord. I'm just reading out.
The evidence is perhaps the father was practicing witchcraft.
Yes, my lord. I'm coming.
କାରଣ ତା ବାପାକୁ ମଧ୍ୟ ସେଇ ଇସ୍ୟୁରେ ରାସ୍ତା ଉପରେ ଆଗରୁ ଘୋଷାଡ଼ିକିନି ନେଇକିନି ପିଟିଛନ୍ତି ବୋଲି ଅଛି ଏଭିଡେନ୍ସ ଯାହା ସେ ଝିଅଟି ଯାହା କହୁଛି ଅବଶ୍ୟ ତାର ସେ ସଂକ୍ରାନ୍ତରେ କୌଣସି ରିପୋର୍ଟ ଦିଆହେଇନି
Page 108. My lord. I'm just a minute. 103, my lord.
Yes,
Page 103. Para 2 last line, my lord. All of them were assaulting both the parents and sister.
Page 100?
103, my lord.
103, just a minute.
All of them were assaulting both the parents and sister by means of lathi, stick and cover. Cover is added, my lord.
Okay.
Crowbar. Alleging that they witchcraft 4 villagers as concerned. They means all the 3 persons. They witchcrafted 4 villagers as consequence of which Biranti and Jamjam of our village died.
No, ये जो witchcraft विषय रे
ଆଜ୍ଞା
ଆଉ ଟିକେ ବୋଧେ କ୍ଲାରିଫାଇ ହେଇଛି ପରେ ସେ ଯୋଉ
108 matter Kori of the Honorable Court, Narayan Court.
ହଁ ହଁ ସେଇ ହଁ ଏଇଟା 107 ରୁ ଷ୍ଟାର୍ଟ ହେଇଛି ସେଇଟା ଟିକେ ପଢିଲା ଆଉ ଥରେ ଏଇଟା ଗୋଟେ
Query made by the court
ହଁ
as to if such allegations are leveled against her family even prior to this incident, and in which year did she discontinue her study. The witness replied, discontinues my study in the year 2009 after passing 7th class examination, and on many occasions in these preceding years, even since grandmother of Dasanta had fallen sick and made allegation against my father that she had dreamed of witchcraft by my father that caused her sick. Villagers had tortured us and even imposed penalty in terms of money on my father. On my father.
ହୁଁ
It might be okay for them.
ହଁ ଏଇଟା ହଉଛି ଇମ୍ପୋର୍ଟାଣ୍ଟ ଏଇ ଲାଇନଟା
It might be okay for them to take revenge against my father, but there is no point to kill my mother and sister, who in their eyes also innocent people.
ତେଣୁ ସେମାନେ ବି ଭାବୁଥିଲେ ସେ କଣ କହୁଛି ଯେ ଯାହା ବି ଇଏ ଥିଲା ତା ବାପା ଏଗେନଷ୍ଟରେ ଥିଲା ବାପାକୁ ସେମାନେ ସନ୍ଦେହ କରୁଥିଲେ କାରଣ ସେ ଦଶନ୍ତର ବୁଢୀ ମା ସିଏ ବେମାର ପଡିଥିଲା ଏବଂ ସିଏ ସ୍ୱପ୍ନରେ ଦେଖିଥିଲା ଯେ PW1 ର ବାପା ତାକୁ ଗୁଣି ଗାରେଡି କରୁଥିଲା ବୋଲି ତେଣୁ ସେଇଥିପାଇଁ ଗାଁ ଲୋକମାନେ ଅତ୍ୟାଚାର କରୁଥିଲେ
In the FIR, my lord,
ହୁଁ
in the FIR, page 17, my lord,
ହୁଁ
he has stated that, he has written that, ତୁମ ସ୍ୱାମୀ ସ୍ତ୍ରୀଙ୍କର ସ୍ୱପ୍ନ ଦେଖି ତାଙ୍କୁ ଜ୍ୱର ହଉଛି.
ଆଚ୍ଛା ଠିକ ଅଛି ଆମେ ଯଦି ଆପଣ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ହେଲା ଏ ବଡ ଭଉଣୀଟାକୁ କାହିଁକି ମାରିଲେ
And for again, when the statement is there, my lord, that is they assert that that might be some allegation against the sister that he is also helping the mother and father of the.
କିଛି ଏଭିଡେନ୍ସ ହିଁ ନାହିଁ ନା
Evidence not.
ଏଇଟା ଯଦି କୌଣସି ବିନା କାରଣରେ ସିଏ ଯାହା କହୁଛି ବିନା କାରଣରେ ଯଦି ବଡ ଭଉଣୀକୁ ମାରିଲେ ତାହେଲେ ଆକୁ କାହିଁ ସ୍ପେୟାର କଲେ PW1 କୁ ତାଙ୍କ ଏଗେନଷ୍ଟରେ ସାକ୍ଷୀ ହବ ବୋଲି
Because initially, my lord, if my lord, the occurrence was a planned manner because initially they tied up the 3 persons of the family.
Very well killed PW,
My lord. But when there may not be any allegation against them, they might have in their mind that these 3 persons are the culprit, my lord. They are doing it. That's why they have asserted the 3 persons and try to put bring the truth from their mouth, my lord. But they are torturing them, and at that moment also they denied that no, now we are not witchcrafting anything, my lord. The father, the mother, and the sister also both all the 3 persons, my lord.
ଯଦି ସେମାନଙ୍କର ଇଣ୍ଟେନସନ ହେଲା ଯେ ଜଣେ ଆଦ୍ୟରୁ ବିଚକ୍ରାଫ୍ଟ କରୁଛି ଯୋଉଥିପାଇଁ ଗାଁ ଲୋକମାନେ ବେମାର ପଡୁଛନ୍ତି କିଏ ମରିଗଲାଣି ଆଙ୍କ ପରିବାରଟାକୁ ସାରିଦବା ମାରିଦବା ତାହେଲେ ଯଦି 3 ଜଣଙ୍କୁ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ସାରିଲେ ଏ ଚତୁର୍ଥ ଲୋକଟା
And my lord, out of 2 persons, my lord, out of these 9 accused persons, 2 are also related to this family, my lord, the informed man. So that they all the families, all others 2 persons, this informed may be an innocent girl. There is no threat to them that he will do anything witchcraft or anything against them. So that may be in their mind. So now this girl will not cannot do anything against us. Because the Dengu Sabar is the father's stepbrother, and Dasanta is the first cousin.
as per evidence of PW1
Yeah.
page 108
According to the court,
if 2 of them were completely innocent. In spite of that, they were killed.
That is the of the
Tari view.
the view.
That
But
view.
what is the view of the accused
Ah.
persons at that moment?
Yeah.
That to be considered, my
Hmm.
He said that even if he says, my lord, the father is concerned, my lord, no other two are not are innocent, my lord.
Hmm.
It is his presumption, his acceptance, my lord. Not that the accused persons who have assaulted the deceased person, my lord, and murdered them. That is their presumption why they killed because of this suspicion, my lord. On the ground of suspicion, they have done it. And because of other poor villagers also died and some are suffering from fever, that it took a decision.
ନାଇଁ ଗୋଟେ ତିନି ଜଣଙ୍କୁ ସେମାନେ ଆଗରୁ ଆଣିକି ରଖିଛନ୍ତି ବାନ୍ଧିଛନ୍ତି ବା ବାଡାବାଡି କରୁଛନ୍ତି ଯାହା ହଉ
Right.
ଆଉ ଜଣକୁ ଆଣିବେ ତାକୁ ସାକ୍ଷୀ କରିକିନି ତାପରେ ଧମକେଇ ଦେଇକିନି ଛାଡିଦେବେ ତାପରେ ଆଉ ତା ଉପରେ କିଛି ନଜର ରଖିବେନି ତ ଭୟର ନଥିବ ଆରେ ଆମେ ଗୋଟେ ଟ୍ରିପଲ ମର୍ଡର କରୁଛୁ ସେ ଯାଇକିନି କାହାକୁ ନା କାହାକୁ ଯଦି କେବେ କହିବ ଏମିତି ଯଦି ଏଇଆ ଘଟଣାଟା ହେଇଥାନ୍ତା ତାକୁ ଏମିତି ଫାଙ୍କା ଛାଡି ଦେଇଥାନ୍ତେ ତାପରେ କିଛି ନଜର ରଖିନଥାନ୍ତେ
ଆମେ ନଜର ରଖିନେ ବୋଲି ତ ଆମେ ଯେହେତୁ ନାହିଁ ଏଭିଡେନ୍ସ କରବଟିଂ ଯେ ନଜର only his evidence her evidence that he was under threat meeting a threat ଦେଇଛନ୍ତି ଏବେ ଦେଇଛନ୍ତି ସେ ମିଟିଂ ରେ କଣ କହୁଛନ୍ତି
ଅର୍ଡିନାରୀ ମିଷ୍ଟର ଦାସ ଅର୍ଡିନାରୀଲି ସେମିତି ହେଲେ ସେ ଝିଅ ତାର ପୁରା ମୁଭମେଣ୍ଟ ଉପରେ କୁଆଡେ ଯାଉଛି କାହା ସାଙ୍ଗରେ ମିଶୁଛି କଣ କଥାବାର୍ତ୍ତା ହଉଛି ତା ଉପରେ ନଜର ରଖିବେ ସେମାନେ ତିନିଟା ମର୍ଡର କରୁଛନ୍ତି ତା ସାମ୍ନାରେ ଯଦି ଆପଣଙ୍କର କେସ୍ ହଉଛି
village ରେ fear psychology is going on also in everybody's mind that there is a occurrence took place and nobody is going to help the girl. They know that because of this witch trap they have murdered the three persons, my lord. And everybody of the village of 25 numbers of houses, my lord, they knew that. And if anybody will help the girl or anybody talk to her or anybody will in any way coming to forward to help the girl, that is called niya pani basunda gohija nagaro gaare. So that threat also there because and also in the meeting they are telling that we have threatened her, he will not disclose anything before the police. That confident that this innocent girl will or this particular informant will not tell anything because of fearness. That fear psychology is given that this fellow is not doing. And the other two brothers are there. They are given also threatened that if you tell the villagers and other persons. So in that consequence, my lord, the overconfident, sometimes the accused person doing such type of things, overconfident that no, the witness should not do. Many places, my lord, such type of things happen that and it is also one type of threat that ଯେହେତୁ witchcraft ଇଏ କରୁଛନ୍ତି ଆମେ ତାକୁ ମାରୁଛୁ ଆଉ nobody else will again do such type of witchcraft in that area. And they also murder the persons to whom them having suspicion that these three persons are involved in the witchcraft, not this person or the present informed matter. So they are not assaulted or not.
Next.
And so far the evidence of my lord, of the witness, my lord, the defense could not able to check the testimony of the period one, my lord, except bringing some minor discrepancies or contradictions, my lord. And also there is another submission there. There is a interested witness, my lord. So my submission is that any other I will go on some decisions, my lord, where if the interested witness is how it will
that you just give in your note,
my
just citation relevant one or two decision, not
Ma'am, only
don't
two.
multiply. Just
Because there is no suggestion that she deposed due to previous enmity, family enmity or personal enmity, my lord.
just
That suggestion is also not given by them. And also,
somebody might be related to the deceased
my lord,
in view of the settled law, that cannot be a ground itself to disbelieve or discard his or her evidence.
and also, my lord,
If his evidence is otherwise
Believable.
believable.
my lord.
So that's a
So-
different thing.
And now, my lord, the 164, I have stated, my lord, that I will also support the cite the decision of 2013, my lord. I will give you, I will submit, my lord. And so far, my lord,
No,
the-
another thing we want to know from you,
my lord,
that when that of course a decision of the Supreme Court is that the witness is of three types. Okay, absolutely reliable, absolutely unreliable, partly reliable, and partly unreliable. If it is absolutely reliable, court has to accept it.
accept all.
There is no nothing request for any seeking for corroboration. If the court finds absolutely unreliable, it is to be discarded. But once it is found to be partly reliable and partly unreliable, then corroboration in material particulars is necessary. So according to you, in what category this witness would come, PW1?
The first category, entirely reliable, my lord. Not in partly, my
In
lord.
spite of all these contradictions,
Contradiction,
in
because there
spite
is
of
no
all
such
her
contradiction,
conduct,
my lord.
you
Because,
want to-
because, my lord, my lord, I have already submitted that so far the occurrence is concerned, my lord, and the entire after the occurrence, what happened that 164 and the deposition is consistent, my lord, and FIR is only regarding the occurrence took place, my lord. So there is no contradiction regarding the other parts, my lord. They have brought some mere contradictions which they have brought. So far, the suggestion is given in the cross examination regarding the 161 statement and the deposition matter. That contradiction which is omitted in the FR and 161.
No, you are right. 164 and court evidence, it is almost
Similar matter.
similar.
So it is totally, it has to trust to the
But the whatever contradictions appearing or omissions appearing, omissions in the sense, ସେଠି ସେ meeting କଥାଟା କହି ନଥିଲା 161 ଇଏରେ first time କହୁଛି, so that was a material, according to them it's a material omission. ସେ ବିଷୟରେ କହିନି, ବର୍ତ୍ତମାନ ଆସି 164 ରେ first time କହୁଛି ବା court ରେ କହୁଛି. So contradiction in the sense X କୁ କହିଥିଲା ବର୍ତ୍ତମାନ ଆସି Y କୁ କହୁଛି, ସେମିତି କିଛି ନାହିଁ.
contradiction, there is no nothing.
ବାକି parts of body ରେ ସେ ଯୋଉ ଆପଣ କହୁଛନ୍ତି ଯୋଉ injection syringe ଇଏ
ସେ
କରିବା, that's minor.
ଗୋଟେ ଛାଡିଛି, ଗୋଟେ crowbar ଗୋଟେ ଅଛି, all these things. And so far the my submission is that the last year theory, my lord, here will apply when the accused persons on 9/9, my lord, 2016 assaulted the deceased person, tortured them, and assaulted till their
They were in moribund condition, not that they were dead.
dead, my lord.
Okay.
They are alive, my lord.
They were alive. When they were taken from the cows,
They are alive, my lord.
they were alive. That is the prosecution.
That is prosecution. And they shifted the dead body, alive persons, the deceased persons from the couch to other place. Now that is the last in by the PW1, my lord. Now the proximity time between the company of the accused persons and the PW1 and the deceased person is so small, my lord, the intervention of other person to kill him, that is malor questionable.
No, after they were taken away from the cow shed,
they again return back to the PW1.
They were back to PW1 and intimated. So you mean to say that in between that anybody else
will
have committed the murder, that is not possible. That is completely ruled out.
So here section 106 comes, madam. They have to give an explanation what happened thereafter. On that basis, I'll cite some decision, ma'am. And so far, last occasion also, last day, Mr. Chand was arguing that there is no blood stain from the blood or injury in the body part of the father. This is. But so far the father is concerned, there is a bleeding in the nose, but there is no injury in the part of the body of the
evidence of PW1.
So far that on that occasion also, last occasion I explained, and now also explain, my lord, that part the assault was by lathi and my lord.
Another, the vital thing they say that what is the evidence that was the very place where the burial took place and also the cremation took place, because there is no eyewitness to that.
No.
Your the scientific report is totally silent.
Totally silent. Also, the bones which are recovered from the
was not.
Some bones are also seized from the spot, but that has not been due to the insufficiency of the.
What is the evidence except the extrajudicial confession, which has been.
Now the 106 is comes, madam. Now I am on the 106, section 106. When the last scene with the Ali persons, the accused persons are there. After that, what happened to them? After that, they didn't find anywhere.
No. See, ଆପଣ ସେଇଟା ଯୋଉଟା କହୁଛନ୍ତି ସେଇଟା ହଉଛି ଆମେ ମାରିକିନି ମାରିଦେଇଛୁ
ସେମାନେ କହୁଛନ୍ତି ଆମେ ମୁଁ କହିବା କଥା ହେଲା ଯେ ଯଦି ସେମାନେ ତାକୁ ନେଇକି ଗଲେ ସେମାନେ ବର୍ତ୍ତମାନ କହୁଛି ଆମେ ମାରିନୁ ବୋଲି ସେମାନଙ୍କ ପ୍ଲି ହେଲା ଯେ ଆମେ କି ଜାଣିନୁ କିନ୍ତୁ ଆଜ ପର ଦ ୱିଟନେସ୍ ସେ ଆସଲ କରୁଛନ୍ତି ଆସଲ କରିକି ତାପରେ ଗଲେ ସେ ନେଇଗଲେ ତାକୁ 1 by 1 ନେଇଗଲେ ଚାଲିଫ ଥିଲେ ସେ ଯୋଉ ନେଇଗଲେ ୱିଟନେସ୍ ଦେଖିଲା PW1 ସେଦିନ ଦେଖିଲା ତା ପରଠାରୁ PW1 ତାଙ୍କୁ ଦେଖିଲି nobody has seen the three deceased person whether they are Ali or not ଯଦି ତାଙ୍କ ଇଏ ହେଲା so this is burden
ଏବଂ ସେମାନେ ଆସିକିନି କହିଛନ୍ତି ଆମେ
ମାରିଛୁ
okay ତେଣୁ they are to, you mean to say that since the three deceased persons were last seen in the company of the accused persons when they left the cow shed and within a very short time they returned back, some of them returned back and intimated to PW1 that they have gone away with the lives of the three deceased. So burden shifts to the accused persons to explain as to what they did after they took. If we believe the evidence of PW1, then what they did with the three deceased, that they have not discharged. That burden 106 you say.
Yes, madam.
All right. So in that light, you want to cite some decision that you give in that written note of submission that 106 heading for the way. There is no explanation given because ultimately what we propose to do, we are keeping this matter to another date for awaiting that report and that affidavit. On that day, we will hear the only death sentence. On that day, we expect that both of you from your side and Swanson, anything you want to file by written note of submission on the death sentence also, on the merits also, you can give it on that day. So that we will close it.
So we will submit the written note.
Yes. Written note of submission, citations also, but it should be precise, not that it should run pages and pages. And in the citations on this point, relevant patina is this, relevant paragraph is this much. It's not necessary to give all those citations also, the Xerox copy or anything like that.
I have.
If you have given, it's all right.
My lord.
Ah.
My lord, I have.
If you have given, it's all right. Just all right. If you have given, all right. That is no problem.
I know.
ନାଇଁ ସାଇଟେସନ କପି କେମିତି ଆପଣ ଜଷ୍ଟ ଏଇ ମାନେ ବହି ଆପଣ ଦିଆହବନି ଆପଣ ସେଇ ଏଇ ଗୁଡାକ ଦେଖେଇଲେ ଦ୍ୟାଟ୍ସ ଅଲ୍ ରାଇଟ୍ ଇଫ୍ ୟୁ ହାଭ୍ ରାଇଟ୍ ଏଇ ପ୍ରଥମ ପେଜ ଟା ତାଙ୍କୁ ଦେଇ ଦିଅନ୍ତୁ ଏଇ ବହି ଗୁଡା କଣ ଆପଣଙ୍କୁ ଦେବେ ନା କଣ ସେଇ so delay in lodging the FIR you have mentioned it right then ଦିଟା ଦେଇଛନ୍ତି death sentence ବି ଦେଇଛନ୍ତି omission not okay 106 wrong 106 ମାନେ ସେଇ ଯୋଉଟା କହୁଛନ୍ତି ଯୋଉ ଗୁହାଳକୁ ଗଲେ ଆଉ ଇଏ ହେଲେ last scene false testimony of witness relation interest or right statement of 164 CRPC ର ଆଚ୍ଛା then corpus delicti not found okay death sentence 3.1 mono acha ତାଙ୍କୁ ସାଇଟେସନ ର ଦିଟା ପେଜ ଯୋଉ ପ୍ରଥମ ଦିଟା ପେଜ ତାଙ୍କୁ ଧରେଇ ଦିଅ ହେଲା ସୋ ଓକେ এটা ରଖିବ କି ନା ସିଲ୍ ମରା now you come to the this offense under which the appellants have been convicted. So, first of all, we want to hear you about this Section 4 of the Odisha Prevention of Witch Hunting Act. What is it? এইটা গুগল এটি বাড়িল দিও ମିଳିଲା କି ଦିଅନ୍ତୁ ଥରେ ଚଳିବ
Here the case matter, the parents matter, the murder or the incident took place matter where.
No, let us see the definition. Then we'll come to this section 4. Section 4 says penalty for witch hunting.
Witch hunting.
You have got that?
Yes, ma'am.
Please read it out.
Whoever except in the cases provided for in subsection 2 commits witch hunting or abets or provokes for witch hunting shall be punishable with imprisonment for a term which may extend to 3 years and with fine, but which shall not be less than 1,000 rupees. 2. Whoever forces any woman, branding her as wish to drink or eat any inedible substance or any other obnoxious substance, or parade her with painted face or body, or commits any similar acts which is derogatory to human dignity, or displaced from her house, shall be punishable with imprisonment for a term which shall not be less than 1 year, but may extend to 5 years and with fine.
Okay, so 4(2) is a little higher offense.
The first one,
it is allegation, right?
Mara.
So 4(1)
4(1) is
that
Mara.
witch hunting ର definition ପଳେଇ ଆସୁଛି।
Aye.
Witch hunting ର definition ଟା ହଉଛି 2D।
2B.
Section 2D।
2B, man.
D for
2D, my lord. Witch hunting means any acts of omission, a commission or conduct on the part of any person, Roman I, identifying, accusing, or defaming a woman as a witch, or harassing, harming, or injuring such woman, whether mentally or physically, or damaging her property. The woman hunting.
So is it relates to only woman, not to anybody else?
Which one?
ତାର definition କି change ହେଇଛି? ଆଉ ଥରେ ପଢନ୍ତୁ।
Madam.
Witch hunting means
Which means
acts of omission,
commission or conduct
on the
part of any person. Any person, madam.
nahi nahi,
Identifying,
person mean accused,
madam. Identifying, accusing, or defaming a woman as a witch.
woman to mark करो।
My lord, woman.
ये जो डाणी पानी
Yes, ma'am.
कहवा कथा तो
Or 2, harassing, harming, or injuring such woman, whether mentally or physically, or damaging her property.
So again, so it is related to
Only woman.
woman. 2A.
Which the definition?
Which means a woman locally known as Dahani, Dayan, or otherwise, who has been identified by any person or persons believing her to be in possession of or is having any evil power for causing any harm to any person or his property. Witchcraft
Again
that
relates to woman.
woman. B. Witchcraft means use of supernatural or magical power with evil intention to call upon
Witchcraft ଆମେ ଯିବାନି। Witchcraft ହଉଛି penalty section 5. We are not concerned about that. We are concerned about section 4, in which the accused persons have been found guilty. So that means you are to adduce evidence that these two ladies, ଏ ଯୋଉ ଦି ଜଣ ମଲେ ହେଲା, ତାଙ୍କ ପାଇଁ ଏଇ ଅଫେନ୍ସ ହିଁ ଲାଗୁ ହବ। ସେ ଏଭିଡେନ୍ସ ଆପଣଙ୍କର କାହିଁ ଯୋଉ ଡେଫିନେସନ କୁ ଇଏ କରିବା ପାଇଁ ୱିଚ୍ ହଣ୍ଟିଂ ତାଙ୍କୁ କରାଯାଉଥିଲା, identifying, accusing and defaming them, any of the two ladies, as a witch, ତମେ ହଉଛ ଡାହାଣୀ, harassing, harming, injuring such woman, whether mentally or physically, or damaging her property. ତେଣୁ ସେ ଦିଟା ସ୍ତ୍ରୀ ଲୋକଙ୍କୁ ଏଭିଡେନ୍ସ କୋଉଠି ଅଛି ଯେ ତାକୁ ଡାହାଣୀ ବୋଲି କହି ତାକୁ ଏ ଆକ୍ୟୁଜ୍ଡ ମାନେ ଅତ୍ୟାଚାର କରୁଥିଲେ, ତାକୁ ଇଞ୍ଜୁରି କରୁଥିଲେ, ତାଙ୍କୁ ଫିଜିକାଲି ବା ମେଣ୍ଟାଲି ହାରାସମେଣ୍ଟ କରୁଥିଲେ ବା ତାଙ୍କର ପ୍ରପର୍ଟିକୁ ଡ୍ୟାମେଜ କରୁଥିଲେ। ଏ ଏଭିଡେନ୍ସ କୋଉଠି ଅଛି ଦେଖାନ୍ତୁ।
ସେଇଟା ହେଲା my lord, ସେଟା first year
ଆପଣ ଏଭିଡେନ୍ସ ହଉ ତ ଗୋଟେ ୱିଟନେସ୍ ଆଉ PW1 ଆଉ ନାଉ କି ଅଛି?
ସେ 1 ର
1 ନମ୍ବର ଦେଖାନ୍ତୁ।
ସେଇଟା actually they also tied up say para 2 my lord 103. All of them were assaulting my both the parents and sisters by means of lathi, stick and cover, alleging that they witchcrafted co-villager, as a consequence of which Viranti and Jamna, our village, died.
Jum.
Jam
Hmm.
died. And the accused person continued to assert. Three of them, they lost respective consciousness.
So এইଗୁଡାକ କହୁଛନ୍ତି ଆସିବ section 4
ଆଜ୍ଞା
ଯେହେତୁ ସମସ୍ତଙ୍କୁ 3 ଜଣଙ୍କୁ ଇଏ କରା
ଆଜ୍ଞା
ତ ଏଇ ଜିନିଷ ତ ବୋଧେ ଏଠି ନଥିବ ଏଫଆଇଆର କି 161 ନ
ଏଠାରେ ମାଲଡ଼ ଅଛି I am reading out ମାଲଡ଼
କରୁନାହାନ୍ତି
ଉକ୍ତ 10 ଜଣ ବନ୍ଧ ହେଇଥିବା ମୋର ବାପା ମା ନାନୀଙ୍କୁ ବାଡେଇ ବାଡେଇ ପଚାରୁଥାନ୍ତି ତୁମେ ମାନେ ଗୁଣି କରି ଗାଁର ଜାମଜମ ଓ ବିରନ୍ତି ଶବରକୁ ମାରିଦେଇଛ ଏବେ ଅନନ୍ତ ଘୁଙ୍ଗୁରି ବୁବୁନାର ଜ୍ୱର ଛାଡୁନାହିଁ ତୁମେ ସ୍ୱାମୀ ସ୍ତ୍ରୀଙ୍କର ସ୍ୱପ୍ନ ଦେଖି ତାଙ୍କୁ ଜ୍ୱର ହଉଛି ତାଙ୍କ ଜ୍ୱର ପାଇଁ ତୁମେ ମାନେ ଦାୟୀ ତେଣୁ ସତ କଥା ମାନିଯାଅ ନଚେତ ତମ ପରିବାରକୁ ମାରି ପୋଡିଦଉ ମୋ ବାପା ମା ଶପଥ କରି କହୁଥାନ୍ତି ଯେ ଆମେ କିଛି ଗୁଣି ଗାରେଡି ଜାଣିନାହୁଁ ଏତିକି ବେଳେ ଦମନ୍ତ ଗୋଟେ ଶ୍ରେଣୀରେ
yes ଏଇଟା ନୁହଁ। So, Mr. Das, that decision is all right. Yes, an explanation ଦେଇନାହାନ୍ତି, but the contention which they are raising that there is no evidence, neither oral evidence nor any evidence from the scientific official that that particular place is the place where the 3 dead bodies were buried, and again those were brought out and exhumed from the burial place, and then that was set. So ତାପରେ ଆପଣଙ୍କର କଣ ଅଛି?
ମାଲଡ଼ ମୁଁ ଗୋଟେ ସାଇଡ୍ ଡିସିସନ ସାଇଡ୍ କରି ଗୋଟେ ଦେଉଛି ଟିକେ ଜଷ୍ଟ ମାଲଡ଼ ଆଇ ଗ୍ଲାନ୍ସ ଅନ୍ ଦ୍ୟାଟ୍ ମାଲଡ଼
ନା ଆପଣ ସେଇଟାକୁ ଅଲଗା କଥା we followed it that ସେ ନେଇ ଯାଇଛନ୍ତି ତାପରେ last scene ଅଛି ପୁଣି ଆସିନାହାନ୍ତି ସେଇଟା ଗୋଟେ ଅଲଗା ଜିନିଷ।
ଡେଡ୍ ବଡି ନମିନି ଲାଭି ଡେଡ୍ ବଡିର କିଛି ସାଇଣ୍ଟିଫିକ ନାହିଁ ଦେନ୍ ଅଲସୋ ଦେଟ୍ ଇଜ ଦ 106 ମାଲଡ଼ ବ୍ଲାକ୍ ମାର୍କ
No, it's all right, but because
In some cases, ସେଥିରେ ଅଛି ଯେ ସେ dead body କୁ
ନାଇଁ ଫୋପାଡି ଦେବେ ଇଏ କରି ପୋଡି ଦେବେ ଷ୍ଟ୍ରିମ୍ ଗୋଟେ ପକେଇ ଦେବେ ଡେଡ୍ ବଡି ମିଳିବ କୋଉଠି ଜଣେ ତେଣୁ ସେଠି ଡେଡ୍ ବଡି ନ ମିଳିଲା but otherwise the evidence is consistent that the accused person did these acts so corpus delicti not found that's not a ground to disbelieve the evidence that's different ସେ ଏଠି ସେମାନେ ଗୋଟେ କହୁଛନ୍ତି ଯେ ଯେହେତୁ ଗୋଟେ ଡେଡ୍ ବଡି ଟା ପୋତା ହେଇକି ରହିଥିଲା ଗୋଟେ from 9 till 15
ସେଇଟା କୋଉଠି ନାହିଁ ଯେ 9 ରୁ 15 ପର୍ଯ୍ୟନ୍ତ ପୋତା ହେଇଥିଲା
ନାଇଁ ଆପଣଙ୍କର
ଆମେ 15 ସିଏ ଖବର ପାଇଲା
ଯେ କାଲି ତାକୁ ବାହାର କରି ପୋଡିଦେଲେ
ହେଲା କିନ୍ତୁ ସେଟା ଆକ୍ଚୁଆଲି ସିଏ ଖବର ପାଇଲା ସିଏ କେବେ ତାକୁ ବାହାର କରି ପୋଡିଛନ୍ତି କଣ କରୁଛନ୍ତି
ଏଫଆଇଆର ଅଛି ନା କାଲି ତାକୁ ବାହାର କରି ଫୋପାଡ଼ି ଦେଲେ ଏବଂ ଏଭିଡେନ୍ସ ରେ ମଧ୍ୟ ଯିଏ ତାଙ୍କୁ ଖବର ଦେଇଛି
କିଏ ସେଟା ଶୁଣିଲା
ହଁ ଇଏ ଶୁଣିଲା ପରା
ଶୁଣିଲା
ମୁଁ କାଲି ଶୁଣିବାକୁ ପାଇଲି ଉକ୍ତ 10 ଜଣ କାଲି ମାନେ 15 ତାରିଖ ଉକ୍ତ 10 ଜଣ ଆସାମୀ ଆସାମୀ ମଶାଣୀକୁ ଯାଇ ସେଇ ଶବ ଗୁଡିକ ବାହାର କରି ପୋଡି ଦେଇଛନ୍ତି କାଲି ଶୁଣିବାକୁ ପାଇଲା ଆଚ୍ଛା but somewhere he has stated that kali taku bahar kari podi deyichanti just let us see that I think in the evidence he has stated for us
page 106 man
page 106 paragraph 6
second third
on 16/9/2016 I came to know that accused persons brought out the dead bodies of my parents and sister from the ditch where they had buried and set fire and set fire to those by pouring kerosene on it on the preceding day
15 ତାରିଖ ନାହିଁ 14 ତାରିଖ
16 ତାରିଖ ଦିନ ମୁଁ ଜାଣିବାକୁ ପାଇଲି 16 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟାରେ ଏତଲା ହେଇଛି 16 ତାରିଖ ଦିନ ମୁଁ ଜାଣିବାକୁ ପାଇଲି
ସେଟା ଯୋଉ 16 ତାରିଖ କହୁଛି ନା ଏଫଆଇଆର ଅଛି 15 ତାରିଖ ଦିନ ଜାଣିବାକୁ ପାଇଲା ବୋଲି wrongly it has been typed in ସେଟା ଯୋଉଟା ହେଇଥିଲା କାରଣ 15 ରେ ହିଁ ସିଏ ଗଲା ନା ଏଇଟା ଖାଲି 16 ତାରିଖ ସେଟା ଯୋଉ ଡିସ୍ପ୍ୟୁଟ କରୁଥିଲେ ଯେତେବେଳେ ମିଷ୍ଟର ଚାନ୍ଦ ହାଉସ ଡିସ୍ପ୍ୟୁଟିଂ
ସିଏ ସେଇଆ ହିଁ କହୁଛନ୍ତି ଯଦି ତାକୁ ତାମାନେ ଏଥିରୁ ଜଣା ପଡୁଛି ଯେ ଯାହା ବି ସେ ଖବର ପାଇଲା ସେଇଟା ହଉଛି ଯେ ଆଜି ଡେଡ୍ ବଡି ଗୁଡାକ 15 ତାରିଖ ଦିନ ବାହାର କରାଗଲା ବା ସେ ଜାଗାରୁ ପୁଣି ବାହାର କରାଇକି ପୁଣି ତାକୁ ପୋଡି ଦିଆଗଲା 3ଟା ଡେଡ୍ ବଡି ତେଣୁ ସେ କହିବା କଥା ଯେ ଏଠି ଡିକମ୍ପୋଜିସନ ହେଇଥାନ୍ତା ଏଠି କିଛି ନା କିଛି ନିଶ୍ଚୟ ମିଳିଥାନ୍ତା
whether is one of part of the whether ସେ ଟାଇମ୍ ରେ କଣ cloud
no all these things you gone through this Modi's jurisprudence that what changes would occur if a body is buried and for 4 to 5 days let us say it was buried on 9th and it was exhumed let us say so ଆପଣଙ୍କ କଥା ହଉ 14 ତାରିଖ ଦିନ तो 9, 10, 11, 12, 13, 14 5-6 दिन जदि गोटे डेड बॉडी टे पोती ହେଇକିନି ରହେ କଣ ତାର ଚେଞ୍ଜେस ଲାଇକଲି ଟୁ କମ ମାନେ ବଡଟା ତ ଆଉ ସେମିତି ପୁରା ବାହାରିବନି ନା ଯେମିତି ଫ୍ରେଶ ହେଇ ସତେଜ ସେ ତ ଆଉ ରେଫ୍ରିଜରେଟର ଭିତରେ ନଥିଲା ତେଣୁ ତାର ଚେଞ୍ଜେସ କଣ ଆସିବ କାରଣ
that I will verify
page 121 ଟା ବି 121 ଯୋଉଟା ହସ୍ଟାଇଲ କରିଛନ୍ତି ତାର ବି ପ୍ରୋସିକ୍ୟୁସନ ଆଣିଛନ୍ତି କୋଉ ଦିନ ପଢି ହେଲା ପୁରା 15 ଲେଖିଛନ୍ତି 120 page 121 page and 120
no you are advancing an argument on that light have you brought out in that Modi's jurisprudence
I brought
ସେଟା ଦେଖିବି
I'll show my lord I'll show just show sir
Modi's jurisprudence ରେ ବା Taylor jurisprudence ରେ ଆପଣ ଦେଖିବେ ଯେ ଚେଞ୍ଜେस କଣ ହବ ମାନେ
ଚେଞ୍ଜେस ହଉଛି ଲର୍ଡସିପ
ପୋତିଲେ ଚେଞ୍ଜେସ କଣ ହବ
ପୋତିଲେ ସର ଚେଞ୍ଜେସ ସାର
ଖାଲି ପୋତିଲେ that is to when they were alive when they were alive my submission is that suppose ପୋତିଲେ ଯୋଉ ନେଇଗଲେ ଝିଅ ତ ବଞ୍ଚିଥିଲେ ନେଇ ଗଲେ
ସେମାନେ ମାରିଲେ କି ସେ
କାହିଁକି ନା ଯଦି ପ୍ରିଜମ୍ପସନ ଆମେ ନବା ଯଦି ସପୋଜ ଯଦି ମାରିଥାନ୍ତେ ସେମାନେ ତାକୁ ସାଙ୍ଗେ ସାଙ୍ଗେ ତା ସାଙ୍ଗେ ସାଙ୍ଗେ ପୋଡ଼ି ବି ଦେଇଥାନ୍ତେ କିନ୍ତୁ ସେମାନେ ଯୋଉ ଭଳିଆ ଟର୍ଚର ତାକୁ ଇଏ କରି ନେଇଛନ୍ତି ପୋତିଛନ୍ତି ଜିଅନ୍ତା ମାନେ ତାକୁ ଟର୍ଚର ଆହୁରି ତାକୁ ହ୍ୟୁମିଲେଟ କରିବା ପାଇଁ ଆହୁରି ଇଏ କରିବା ପାଇଁ ତାକୁ ପୋତିଛନ୍ତି ପୋତିଲା ପରେ 2 ଦିନ ପରେ ଯଦି କି ଦିନ ପରେ ଯଦି ମରିଛନ୍ତି ଭାବିଛନ୍ତି ତାକୁ ଆଣି ପୁଣି ତାକୁ ପୋଡ଼ିଛନ୍ତି that is the ground my lord regarding the death sentence my lord
no that's a we are not on death sentence now I mean we just want to know
So
that what are the changes likely to occur? Suppose let us say that a person is dead and his dead body is buried. So after 5 to 6 days, ତାକୁ exhume କରାଯିବ କୋଉ condition ରେ ordinarily ମିଳିବ
I'll do that.
ସେଇଟାକୁ ଦେଖନ୍ତୁ କାରଣ ସିଏ କହିବା କଥା ତାଙ୍କର ଆଡଭାନ୍ସ ହଉଛି କିଛି ନା କିଛି ମାନେ ଯଦି ଡିକମ୍ପୋଜିସନ ଷ୍ଟାର୍ଟ ହେଇଯିବ ତା ଦେହରେ ଫର୍ମେସନ ହବ ମଗେଜ ବିଭିନ୍ନ ପ୍ରକାର ସେଇଠି ବହୁତ ଜିନିଷ ସେଠୁ ମିଳିଯିବ ସେ ପୋତିବା ଜାଗାରୁ ଯୋଉଥିରୁ ଜଣା ପଡିଯିବ ଯେ ଏଗୁଡାକ ସବୁ ଏଠି ଇଏ ହେଇଥିଲା ଏଠି ଡେଡ ବଡି ଏଠି ରହିଥିଲା ତେଣୁ ସେଇଗୁଡାକ ଆପଣଙ୍କ ସାଇଣ୍ଟିଫିକ ଅଫିସର କିଛି ପାଇଲେନି ସେ ଜାଗାରୁ ପୋଡିଦେଲା ପରେ ଅଲଗା କଥା କାରଣ ଆପଣଙ୍କର ସି ରିପୋର୍ଟ ଯୋଉ ଦେଖେଇଛନ୍ତି ସେ ରିପୋର୍ଟରେ ଏକ୍ସପ୍ଲାନେସନ ଦେଇଛନ୍ତି ସିଏ ଯେ ପୁରା ଟୋଟାଲ ସେ ଏମିତି ହେଇଯାଇଥିଲା ଯେ ତା ଦେହରୁ କିଛି ମିଳିଲାନି ହଁ ଏଇଟା ହଉଛି ପେଜ 157 ରେ ସେ କହୁଛନ୍ତି DNA profile is not possible to be generated from the 25ଟା piece ଯୋଉ burnt ତାର as the bones were burnt completely and the required quantity of DNA could not be extracted from that. ତେଣୁ ସେଟା ସମ୍ପୂର୍ଣ୍ଣ ଭାବେ ଇଏ ହେଇଯାଇଥିଲା ତେଣୁ ତା ଦେହର କୌଣସି DNA ପ୍ରୋଫାଇଲ ସୃଷ୍ଟି କରିବା ପାଇଁ ଆଉ ନାହିଁ so that's a different matter ତେଣୁ but ଏଇ ଯୋଉ ଜାଗାଟା କାରଣ admittedly ଗୋଟେ ଜାଗାରେ ପୋତା ହେଇଛି ସରି admittedly ନୁହେଁ ଦେଖେଇଛନ୍ତି ଆପଣଙ୍କର ସ୍ପଟ ମ୍ୟାପ ରେ ଏଇ ଜାଗାଟା ହଉଛି ପୋତା ହେଇଛି ଆଉ ଗୋଟେ ଜାଗାରେ ଆପଣ ତାକୁ କାଢିକି ପୋଡୁଛନ୍ତି ପାଖାପାଖି
10-15 to 15 feet totally.
Have you, Mr. Das, have you aware about what is the status of this PW1 and those two children now?
It was already married. Got married too and living in another village.
Where from you got it?
This is the last time you did evidence by the put it now.
Oh, acha.
Evidence
last PW married. The ଛୁଆ ଦିଟା ତାର ଯୋଉ ଭାଇ ଦିଟା
ସେଟା
ଟିକେ ascertain କରିଦିଅନ୍ତୁ ଭାଇ ଏଇ ସିଜରିଆ ନା କାରଣ ସେତେବେଳେ ସେମାନେ ସ୍କୁଲରେ ପଢୁଥିଲେ 2016 ମସିହାର ଘଟଣା 8 ବର୍ଷ ହେଇଛି ନା ହଁ
ସେଟା evidence job କରୁଥିଲା ବାଙ୍ଗାଲୋରରେ
yes anything else Mr. ସେଟା ଦେଖିବେ ଆପଣ ଦେଖିଦେବେ ତାକୁ ମଧ୍ୟ ଯଦି ଇଏ କରିନାହାନ୍ତି ନୋଟରେ ଇନକ୍ଲୁଡ କରିଦେବେ ତାକୁ ଟିକେ ସର୍ଟ Mr. Chan, you and both of you, whatever you want to prepare, just prepare it as short note. ଆପଣ ଗୁଡାକ harm କରିଦିଅନ୍ତୁ ଆଉ ଯାହା କହିବେ ଆପଣ ମୁଁ ନାହିଁ ଆଉ ସାଇଟେସନ ମଧ୍ୟ ଯୋଉଟା ଦେବେ ଖାଲି ପାର୍ଟି ନା ସାଇଟେସନ ଦେଇକି ଖାଲି କୋଉ ପଏଣ୍ଟ ରେ ଏଇ ପଏଣ୍ଟ ରେ ଆମେ ଦଉଛନ୍ତି ଆପଣ ସେଟା ହଉଛି ହଁ ସେଇ ଟାଇପ ର yes anything you want to now add
point wise I have made
okay
नहीं कर दिया
yes steel marking so you have had the submission any reply you want so otherwise we'll just close it only for the purpose of hearing and the sentence we'll keep it on another date
just meet your lordship point my lord what was raised lordship that is That to what my friend stated, my lord, the date of cremation.
Please use the mic properly.
Yes, my
They are hearing you.
Sorry, sir.
Yes.
As for the date of cremation, my lord,
Hmm.
that was what my lord and friend submitted, my lord.
Hmm.
That as far as the evidence, as well as from evidence available from the evidence of the prosecution, my lord, that was the 15/9/2016, my lord.
Where from you got it?
My lord, your lordship. Your lordship, may kindly see it. Page 120, 121, my lord. Page 121.
Hmm.
No doubt they have, as far as the evidence from the PW1, your lordship read it. As far as
121 कहाँ evidence होता?
121 Gona Sabor, my lord.
कौन सी कोई?
Page 120. Your lordship, as the prosecution has turned in hostile, my lord. Then your lordship, paragraph 2. It is not a fact that I had stated before the police that I had heard that Osina, his wife Pompey, and their daughter Asmani were taken to the cowshed of Gibson Sabor, where they tied them in the stock meant for the cows, assaulted them, and killed them after taking them to the cremation ground, and that in the night of 15/9/2016, all the 10 accused persons removed those bodies from the burial, pour kerosene and petrol.
और आपण आदिर कौन देखियो चाहते हैं?
That is,
Well, 161 statement. Is it a substantive evidence or what?
well, that was that
आपने इटा ताको पचाले से मना कला आपण आयु जरिया प्रमाण करेले.
prosecution, my
But it is after all a 161 statement.
lord.
So
Yes.
from that you cannot say that on 15 this thing has taken
That is
place.
the prosecution case, my lord. That is
अरे
prosecution
बाबा, आपण
on
सेटा 161 statement रे अछि. 161 statement रे अछि जे सिओ कहितला 15 तारिख रे. 161 statement रो किंती हम यूटिलाइज करबो दैट इज गॉट a limited purpose.
and they confronted to
It's all right. It has been confronted. It has been proved. But that witness has turned hostile, and we are to the principle how far we can utilize it. That 161 statement that is also settled.
similarly the evidence of the six hostile जोड़ा करछंदी तापर ओटे
ତାଙ୍କର ପଜିଟିଭ ଏଭିଡେନ୍ସ ଆସୁଛି ଯେ ଏଫଆଇଆର ଅଛି ଯେ ମୁଁ ଶୁଣିଲି ଏବଂ ଏଥିରେ ଆସୁଛି ଯୋଉ 16 ତାରିଖ ଦିନ ଶୁଣିଲି ତା ପୂର୍ବ ଦିନ ପୋଡ଼ି ଦେଇଛନ୍ତି. that you can say that is a positive evidence as well.
preceding day by preceding day.
Okay, anything else?
My lord, another point, my lord. But as far as the abduction part is concerned, my lord, your charge, your lordship will kindly see. Just one point, one line, I would say. Charge part, your lordship will kindly see.
Page.
Lordship.
$364 or $365?
Second chapter.
Page 21, my lord.
Wait. 364 टा प्लेस करूँ 365 प्लेस करूँ तापर जीवा चार्ज.
Sir.
Are you having that book? Okay. First place 364.
364.
Yeah.
360.
Use the mic properly.
364. Kidnapping or abducting in order to murder. Whoever kidnaps or abducts any person in order that such person may be murdered or may be so disposed of as to be put in danger of being murdered shall be punished with imprisonment of life or rigorous imprisonment or a term which may extend to 10 years and shall also be liable to fine. Thereafter,
365.
365, my lord. Kidnapping or abducting with intent secretly and wrongfully to confine person. Whoever kidnaps or abducts any person with intent to cause that person to be secretly or wrongfully confined shall be punished with imprisonment of either description or a term which may extend to 7 years and shall also be liable to fine.
So secretly and wrongfully confined.
Confined, yes.
A charge कौन पे frame is
Sir,
देखते?
charge your lordship may kindly see. So, page 21.
365 को आगे पढ़े सुन. Hardly जोटा है.
Thirdly, secondly or thirdly, dita ko. Second 364, और 365.
365 तक आगे सुन.
My lord, that on the same day, time and place, you along with others, in furtherance of your common intention, abducted Melita Sabar, or father Asina Sabar, or mother Ambaya Sabar, and elder sister Osmani Sabar, with intent to cause them to be secretly or wrongfully confined, and you have thereby committed an offence punishable under section 365, read with 34 of the Indian Penal Code, and with my cognizance.
Okay, next secondly पढ़ो.
Secondly, that on about the same day, time and place, you along with others, in furtherance of your common intention, abducted Melita Sabar, her father Esina Sabar, her mother Ambaya Sabar, elder sister Osmani Sabar, and tied them in a rope in the cattle shed of Girjan Sabar, a co-villager, and again removed Asina Sabar, Ambaya Sabar, and Osmani Sabar from the cattle shed to an unknown place in order that the said 3 persons be put in danger of being murdered, and you threatened Melita Sabar in order that she might be murdered, and thereby you have committed an offence under section punishable under section 364, read with 34 of the Indian Penal Code, and within my cognizance.
What is your submission?
My lord, as far as the 364 365 is concerned, my lord, they brought it from the evidence of the PW1 that when Damanta Sabar said that they have been abducted. That is the statement, my lord. Damanta Sabar said that the 3 persons have been abducted. Thereafter, he said that your parents and sister are being tied there. Thereafter, she went. So, these charge frames that Melita Sabar was kidnapped, abducted, as well as the 3 persons have been abducted. But only basing on the information of the Damanta Sabar. But there is no such material from the Damanta Sabar that he have been abducted. So, abduction part is completely silent. Nobody has said.
Just a minute. Come to that abduction definition.
Abduction definition. My lord. Abduction. 62.
Definition.
Whoever by force compels or by any deceitful means induces any person to go from any place is said to abduct that person.
So what you mean to say that this particular charge, according to the prosecution, is based on the statement of PW1. And PW1 has no knowledge about this part, but she stated to have heard it from one person whose name is ଦମନ୍ତ ନା କଣ କହିଲେ?
ଦମନ୍ତ ଶବର।
କାହିଁ ସେ ଆସିଲେ ସେ ଏଭିଡେନ୍ସ କୁ?
Para 2, page 109.
Yes, just a minute.
103, sorry.
Wait.
103, 103. Para 2,
Damanta Sabar of our village, paragraph 2.
Sir,
Of our village informed me that my parents and sisters were being tired of so and so, so and so.
I rushed to the spot. And I cried after their aftermath.
Not examined.
That's not the
Mr. Das, just if you dita sections se jo padhile 364 and 365 So it's a case of, let us say, abduction review definition. Abduction definition hochi gote one of the important criteria. Upon definition देखंतु
Abduction. Whoever by force
compels
or by any
deceitful means. Deceitful means छाड़ दियंतु.
Right.
Whoever by force compels any person to go from any place गोटे जगारू ताकू जबरदस्ती नहीं जीवाकू गोटे कहंती abduction हैला. तो एठी तारो ठीक अच्छी से तीन जन को ये देखिला काउ सेट भितर बंधा ହେଇକି ଥିଲେ. तो सेमाने कोउ जगारे थिले तांकू जबरदस्ती आनिकिनी बांधिले ये एविडेंस किछि अछि कि आपन को?
No, that is not that. ये देखले ही बंधा है।
काउ सेट रे खाली बंधा अवस्था रे पाइले जे abduction हेई जीवो तीन जन को मनकर लेटर से आउ किछि एविडेंस नाही, पॉजिटिव एविडेंस नाही, तीन जन को गोटे काउ सेड रे accused persons माने बांधी देई छै. Can it be said that they have abducted in view of the definition?
So that is not the place where they are staying. This is a place where they have brought.
No.
Because unless until they brought to that place and they're tied up.
No.
Unless until abduction is there.
You see, each of the definition, prosecution has to prove. It's not that
Exactly.
prosecution प्रमाण करेइबो जे abduction ର definition ଟା satisfy होची. जेमति आपण witch hunting रो देखैले तेणु तांकु forcibly तांकु अणा जाइछि. अच्छा से forcibly अणा जाइछि ता देरे किए पार्टिसिपेट करिसंती बुझी परछन तो. Let us say X and Y forcibly brought the three deceased to the cow shed, and in that abduction others did not participate. Others came subsequently. They just assaulted. So can it be said that abduction which AX and Y did, that was with the common intention of so and so, unless you brought some evidence? Or can it be said that those persons who assaulted, they can also be punished under section 364, 365, unless there is some sort of preconcept of mind or something like that? आपनकर एविडेंस ही किछि नाही, कोठी समाने थिले, को भरी अवस्था रे तांको अणा गला
सेठी
बंधा आइछि आपन अछि.
सेटे गोटे मो से डिसीजन ने गोटे अछि भी साइटेड वन डिसीजन वाला जोतरे अछि जे जणे भी एडॉप्शन करिक आनिछि अन्य अन्य पार्टिसिपेट तापर करछन मर्डर हेछि and all will be included in that adoption matter. All are responsible for that. There is that decision. I will also I will also place that. That is there. जदि जणे भी ताको ये करिक आनिछि adoption करि आनिछि माने and thereafter they murder them. They all are responsible for that.
No, 302 assume.
No, abduction.
Which is that decision you say? Let us see. The coach. ता देर जदि एविडेंस थिबो जे प्री कॉन्सेप्ट ऑफ माइंड थिला से माने गोटे प्लान चेक आउट करथिले तापरे से लोकटा को दायित्व दिया हितला जोथि पई सी abduction करी नानला तापरे माने पार्टिसिपेट करी मर्डर करले, then the matter is different. But दी तीन जण लोक abduction करी नाइले तापरे अन्य माने परे आइले आसिले ताकू असॉल्ट रे पार्टिसिपेट कले तो सेमानकू अब एठी आपनकर टोटल एविडेंस ही नाही माने किए abduction कला कोठु आनिला केमती से माने गुहार घर भितर को आसिले आपनकर एविडेंस होची PW1 जे कोची मु आसिला बडो देखिले तीन जण को बंधा गयो. So that is that wrongful confinement is attracted. There is no problem in that. But abduction by something more is necessary apart from these things. That appears to be on a plain reading, subject to what you say. You just find out is any other submission. That's all.
ସେଥିରେ ତେଣୁ ମେଲିତା ଶବର ଆବଡକ୍ସନ ଟା ନାହିଁ ମେଲିତା ଶବର ଯୋଉ ଚାର୍ଜ ଫ୍ରେମ ହେଲା ମେଲିତା ଶବର ଏବଂ 3 ଜଣ ସେ ଯୋଉ ଡିସିଜ୍ 3 ଜଣ ତାକୁ ଯୋଉଟା ଆବଡକ୍ସନ ହେଲା ମେଲିତା ଶବର ଆବଡକ୍ସନ ଆଦୌ ନାହିଁ ଏବଂ ପାରାଗ୍ରାଫ 106 ପେଜ 106 paragraph 9 if you lordship will see
No, ମେଲିତା ଶବର କୁ କେହି ତ ଆବଡକ୍ସନ କରିନାହାନ୍ତି ମେଲିତା ଶବର ତା ଖବର ପାଇକିନି ସୋ ମତକୁ ଆସିଛି ଆଉ କଣ ସେଠି
charge there that same saying charge was there that melita sabar and those other 3 persons they were abducted
melita sabar pai abduction is no
charge
that is there
melita sabar tar se nije asila
page 21
just
same pai kouch na at on our same time place you allow with others
melita sabar
abducted melita sabar or father asina sabar or mother asina sabar and
similarly thirdly with
thirdly the basic section say melita sabar and those 3 deceased persons
364
evidence ଅଛି ସେ ତାର ଆଠୁ ଶୁଣିକି ନିଜେ ଆସିଲା ପରେ ତାକୁ ବାନ୍ଧେଇଛନ୍ତି that is wrongful restraint that is 342 ପାଇଁ ରହୁଛି
ତାପରେ 106 ପେଜ ରେ
wrongful confinement
cross examination ସେ କହୁଛି ଦମନ୍ତ informed me about the abduction by parents and sister and their confinement inside the cow shed page 106 page paragraph 9 ସେତିକି କିନ୍ତୁ ଦମନ୍ତ ଦମନ୍ତର ଅଲଗା ପାର୍ଟ ବି କହିଛି ଧମକେଇକି ରଖିଲେ ପଛେ ଜଗିକି ରହିଲା neither he has been added an accused though he has been added as a witness he has not been examined
ଦମନ୍ତ କୋଉ ଦମନ୍ତ ତାର ଏକା ଭଳିଆ ନା
ଦମନ୍ତ ଦଶମନ୍ତ ଅଲଗା ସାର୍ ଦମନ୍ତରେ ସେ ଆଡମିଟ କରୁଛନ୍ତି ଯେ ଦମନ୍ତକୁ ମୁଁ ଇଏ କରିନି ଆକ୍ୟୁଜ କରିନି କିନ୍ତୁ ଦମନ୍ତ କହୁଛି ଏଫଆଇଆର କହୁଛି 164 କହୁଛନ୍ତି ଦମନ୍ତ କହିଲା ପଠେଇଲି ଯା ଧରି ପକାଅ ତାକୁ ବାନ୍ଧ ତାପରେ ବନ୍ଧା ହେଲା
you are right that she got the information from Damant about this but Damant has not been examined that is you are right
Damant has been examined
ସେଟା ଆଉଥରେ ମୁଁ ପଢୁଛି
ତାପରେ କୋର୍ଟ ଏଟାକୁ ଡିଲ୍ କରୁଛନ୍ତି
62 abduction whoever by force compels any person to go from any place means by force suppose ମୁଁ ଏଠି ଅଛି ମତେ ଏଠୁ ଅନ୍ୟ ଜାଗାକୁ ନ ଯିବା ପାଇଁ ମତେ କମ୍ପେଲ କରି ରଖିଛି that is abduction not that ମୁଁ ତାକୁ କୋଉଠି ନେଇକି ଆସିଲି କମ୍ପେଲ କରିକି ଜବରଦସ୍ତ ନେଇକି ଆସିଲି so here my lord
you mean to say that from taking of from the cow shed to the other place that also can be said to be abduction
no my submission is that the inside the cow shed that tied up
means for that 342 is there
364 my lord 362 abduction name coach ସେଥିରେ କହୁଛି abduction meaning ରେ ଆସନା whoever by force compel any person to go from any place ମାନେ ମତେ ଏଠୁ ଅନ୍ୟ କୋଉ ଜାଗାକୁ ଯିବାକୁ ନ ଯିବା ପାଇଁ ଫୋର୍ସ କି ରଖା ହେଲା that is abduction
to go no to go from any place means ଏଇ ଜାଗାରୁ ଆଉ ଗୋଟେ ଜାଗାକୁ ନେଇ ଯିବାକୁ ତାକୁ କଣ ଏଇ ଜାଗାରୁ ଆଉ ଗୋଟେ ଜାଗାକୁ ନବାକୁ କହନ୍ତି to go from any place force ୟୁଜ କରିକିନି ଗୋଟେ ଜାଗାରୁ ଜବରଦସ୍ତି ନେଇ ଯିବାକୁ ତାକୁ କହନ୍ତି abduction to go from any place.
Any-
X जगह थिला X जगह तो कोई जबरदस्ती नहीं जीवा को हैला abduction है ना, that is abduction. वो जगह को नेला, that is not relevant, but the moment you took a person by force, okay, that would be abduction or by deceitful means. And it will not come obviously on kidnapping because that is age restriction is there. So it is only abduction will come. So abduction evidence asuchi je he was told, she was told by Mr. X that your parents have been abducted. Your parents and sister have been abducted. So if X has not been examined, then it becomes a hearsay evidence. So far as that particular offense is concerned, the source of knowledge is Mr. X. Otherwise, what he has seen, it's all right. She had seen confinement, 342 is there. That part is not on her personal knowledge. That part is based on
On the basis of the
somebody's
information, he went to the place.
right. So that information which she has got from Mr. X, Mr. X has not been examined. So it is to be segregated like that. Because a particular charge now depends upon this particular statement of the PW1 that मते दशंत कहिला तो बापा माँ भौणी को नहीं जाइछंती हाँ दमंत कहला ये जो दीटा चार्ज आपण ये करिसेंती तारो से दीटा जाको डिपेंड करूची
I'll place that abduction.
just think over it. We are just pointing out. Actually, you are not right only because this 364 charge is something else. The 364 charge जो आपण देखिबे ताकू फ्रेम होईची एथि पई जे कैटल शेड रो अननोन प्लेस को नहीं जीवा पई सेही चार्ज टा फ्रेम होईची 364
Cattle shed जो नहीं गला
कैटल शेड रो जो जबरदस्ती नहीं गले हां सेहीटा होची 364 आसीबो. That is by force they took.
କିନ୍ତୁ ସେ ଯୋଉ ଚାର୍ଜ ଫ୍ରେମ କରୁଛନ୍ତି ସେ ବାନ୍ଧିବାଟା ନେଇ କରୁଛନ୍ତି that they are
ବାନ୍ଧିବାଟା ଅଛି ତ 342 ଅଛି
ସେଇଟା ସେମାନେ କରୁଛନ୍ତି
ହଁ
ଅଦରୱାଇଜ ସେଟା ହେଲା ନେଇ ଗଲେ ସେଠକୁ
ଏପା ଲେଖା ହେଇଛି so from the cow shed to an unknown place in order that the said person should be put in danger of being murdered. So that is exactly it is not that from bringing them to that person, but it is taking out which is this PW1 is a direct witness to that.
ନେଇ ଗଲା ତାଙ୍କ
All right, yes, anything else or we'll close it so far as this merit is concerned.
other data charge be that is defective. Third of fourth and fifth. Fourth and fifth lordship currently that on the same day time and in on the same day time and in the cremation ground Mosani of village Kitun, you along with others in furtherance of a common intention committed murder by intentionally causing the death of Asina Sabar, Baya Sabar and Asan Sabar and committed the offense punishable under 302 read with 34 of IPC.
Yes, what is your
stage माने तार बहुत कम गया था से कहते सेठी मर्डर कलो कोठी at the time of cremation ground रे सेठी मर्डर कलो सेही दिन on the 9/9/2016 रे सेठी मर्डर कलो बोली गोटे एलिगेशन सेउटा होची चार्जटा एटा
कोन हला तार स्टेटमेंट आसिला ସେମାନେ ଆସିକି କହିଲେ ଆମେ murder କରିକିନା ଆସିଲୁ. That is the evidence of PW1 and the decision which is citing. X and Y took the deceased after assaulting him, and then thereafter her whereabouts is not known.
Yes.
And if the dead body is found or not found, that's immaterial, because the burden then shifts to you.
Yes.
You have to say that when the deceased was in your company, what you did with the deceased.
Commission ରହୁଛି ସେଟା ସେଇଟା ସାର୍ ନେକ୍ସଟ ହଉଛି ସେଇଦିନ କ୍ରିମେସନ କଲ ବୋଲି ସେଇଦିନ ଅନ୍ ଦ ସେମ୍ ଡେ 5th that on the same day time and on the cremation in the cremation ground of the village.
In the cremation ground you committed the murder, in not that you cremated the dead body.
On the same day.
Oh, on the same day so and so you committed the murder.
ସରିଲା ତାପରେ
Murder has taken place on 9th. Body has taken place on 9th. Exhumed and cremated on 15th. That is the prosecution case,
page
or
20.
maybe prior to that, whatever.
Page 22. That the continuation, my lord. Page 20. Punishable with death or imprisonment of life has been committed. Cremated the dead bodies of Asina Sabar and others, my lord, to disappear evidence. But on the I am questioning, my lord, on the same day. That on the same day you did this. So where they got it? That is why I am questioning, my lord. I am just pointing out. And all are same day means 9/9/2016.
Knowing or believe that the offense of murder has been committed, it has been cremated the dead body, so on. ଏଇଟା ଆପଣଙ୍କର
ସେଇ ଗୋଟା କହିଛି
201 में जो cremation the same day word usage that is not correct. But
କହିଥିଲେ ଅନ୍ୟ ଗୋଟେ ଡେଟ୍ ଲେଖିଥାନ୍ତି କିନ୍ତୁ ଲେଖି ନାହାନ୍ତି.
So right, but how you are prejudiced in that way? 201 નો charge ହେଇଛି ଆପଣ basically ଆପଣ aware ହେଲେ ଯେ cremation ଆପଣ ନେଇକିନି cremation କରୁଛନ୍ତି same day what ଟା use ହେଇଯାଇଛି
and that is only pointing out.
Yes, the charge is defective to such an extent that it has caused serious prejudice. Cannot be on that ground. Yes, anything else? Mr. Chand?
ଆଉ ଗୋଟିଏ ସାର୍ ପଏଣ୍ଟ ହଉଛି ଅଜନ୍ତ ବୁବୁନ ଯାହା କହୁଛନ୍ତି ଆକ୍ୟୁଜ ସେମାନେ କହୁଛନ୍ତି ଯୋଉ ସ୍ୱପ୍ନ ଦେଖିଲୁ ଯୋଉ ଜର ହଉଥିଲା ଲାଗୁଥିଲା ଅଜନ୍ତ ବୁବୁନ ଘୁଙ୍ଗୁରି ଅଜନ୍ତ ବୁବୁନ ତା ଦେହରେ ହଉଛନ୍ତି 2 ଜଣ ଯାକ ସେମାନେ they have taken part in the assault, but they say but they were suffering. That what I submit, my lord, that is unbelievable. If that is correct, if the version of the PW1 is correct and Ajanta Bubuna was suffering, then how did they come and join the hand with others to assault that thing I point out.
All right. Yes, Mr. Khan.
The entire case is based on now the sole testimony of the prosecutors, that is one. And as the last 2-3 occasions, it is my contention, and my other state is also on the way contradicting it, that in fact the condition and the mindset of the concerned girl, whether to keep mum from 9th to 16th, and if on this score, if I had found that she was having a free mind and she was moving everywhere, she was regular in a manner, she was having his normal work. So whether this particular activities or her last explanation, which she has said that because of the fact that I came to know about cremation of the body, and thereafter, I somehow feel it proper to lodge the affair, how far it is believable, In the affair, as I have from the very beginning harping upon, it's a development in the affair, see, that part is also there. In the affair last part, page 16, the IO has also said, because delay was due to inflicted of death threat by accused persons to the informant and her brother. So these things have been pointed out by the concerned IO in the affair, in the this formal affair. So my humble submission, when these things was there in the affair, and prosecution has also to come to this extent, it was also within the knowledge of the concerned IO that this death threat was there. It was the duty of the concerned prosecution at least to to collect evidence that when the things was there, when the threat was there, and to what extent it was there. Mere by saying that the threatening was there, and the threatening was there on 9th. You might take note of this aspect that the entirety of the period evidence that the threatening was on 9th evening, or the 9th night when she went to the police cowshed, where she found that her parents and other sister were assaulted, and while they were taking away from the particular cowshed, a threatening was there. That was there, and it is also further case that two persons who are also not accused, my lord, they have guarded her. And after some time, after the things was materialized, and one of them has handed over the gold chain to the informant, my lord, there it was also said to not to disclose. And so far the other aspect is concerned in the threatening in the particular hilltop, and this threatening of after coming from the when the body was taken, all the living body was taken away, and when the gold chain was returned, this threatening and the threatening allegedly made in the hilltop. This thing was neither in the affair nor also in the statement of the 161 ballot. Then that has been confronted to the concerned IO. This, when the contradiction was brought up and confronted, IO admitted that this ballot that is there. So my humble submission, when this threat will go, because the entirety is now dressed up in this threat, and if my lord had to consider whether this threat can up to this extreme stage that which has prevented the girl of 22 years, not of minor also 22 years, and also as if my lord take note of the prior threatening which was occurred in the year 2011, 2018 as 2011 and 16, 2008 and 11, which was about 5-6 years before the alleged occurrence, and if that is a continuing one, and when she came to know about the death of her parents or the death of entire family members on 9th itself, why she has kept mum? So my humble submission, because of the fact that just to see that it was not within her knowledge, and technoprobe, because no corroboration, nothing is there, that she was even present. And as I have last time I tried to convince my lord, and because the cowshed was not there, and all these things as a setup one, and this state was not because of the fact that she was not at all there in the particular field, my lord, and when she came to know about the death, who committed, I don't know. Who has committed things has come up, but rather we might take note of it was because of the cholera, as has been presented by some of the witnesses. Now she has come up with a new story, and that has also been supported by the IO to this extent. The IO has also said that because of the death threat, this thing has come up. So if my lord will take note of this death threat, even if that death threat is there, whether a normal being, normal person can hear this threat, if a contrary will be there, but a comparison will be there whether this threat on one hand, other hand, loss of 3 family members on the other, my lord. My humble submission in a particular case, even if I do consider that persons are having different mindset, they can come off to and lose the affair because of their choice, or in the mindset it differs from person to person. But my humble submission, with this knowledge of the elimination of 3 persons who are the headmen of the particular family, it is not at all expected on the part of a normal persons to keep mum for 5 days if she is moving freely. And it is a case of the prosecution that she was moving freely. She was never under any lock and key. That is my submission so far. The third part is concerned, and under this, because of the fact that the entire thing has been developed one, and the thing she was living in a free manner, so no portion thread was there, and the distance is also very short for her to approach the concerned police, my lord. And the other aspect, my lord, it is the case that on 9-10, my lord, the funeral work was there, and it is her case that she came to know that on 15th. So my humble submission, because of the fact that as I pointed out, the body, as I have already started, I will put it in the statement. The body decomposition starts from 24 hours, my lord. The rigor mortis starts, follows at 48 hours, all of the hair is there, and chemicals will come up from mouth, nostril, eyes, my lord. The body will compose, and by the process, chemicals will come up. So all these things were definitely available, required to be available on the spot, my lord, but nothing has been come up. And it is the case of the prosecution. After these things were there, they covered up by scent. some I said. But this report of S.A. is totally silent. Nothing was there, as if nothing has happened, and there is absolutely nothing in the particular place of cremation. First, where it was allegedly there, and if I will take note of that girl's evidence, then it was there for 5 days, and during this 5 days, no materials has come up that it was there, and if they had it been there, then matter would have been something different, and at least something will come up. So my humble submission, this story of burial of the body for 3 bodies for the 5 days is a totally false one, and it's again a development to see that these things will have to for some public purpose. And as Malad knows, the village nowadays, political hostility and everything is very common. And by this process, she wants for any previous grudge, or because of the fact that there was some 2008 or 11, there was some enmity because of something. This thing has come up, Malad. And the other one, two things I want to also. I do concede that last thing that is there, if I have taken note of the evidence of that they were taken off. This last scene, because of the fact that, yes, of course, I do consider that because of the fact that even if I take note of this aspect, let's say admitting for the sake of argument that there was some assault and all the 3 persons were taken away. So my humble submission, after these 3 persons were taken away, who are the persons who have committed the murder? If up to this extent, my humble submission is let us accept that there was an assault. Let us accept there was some this restraining the persons and assaulting them with murder's intention. But subsequently, when they are taken away, who is the person? Because 9 persons were there. Who are the persons? Suppose I am giving to some extent a picture. Suppose after this particular person, out of 9 persons, 7 has fled away, and the rest 2 have committed the murder. Or because of the fact that take note of, it is all allegation. All the villagers were having enmity with those with this father and mother, and only the father. But suppose let us say that father, mother, and the sister, they are having some enmity with the all villagers. But anybody of the villagers might have committed the murder. If that is
Mr. Chand, what he is telling by showing that decision, that once the evidence is accepted that you have taken away those 3 persons from the causa, the next moment the burden shifts to you. You have not said that yes, thereafter I left the company of the other accused persons, or I went to some other place, or X and Y, Z, they were waiting there in the cremation ground, they committed the murder. So you are to say it, not that the prosecution to say, because admittedly on that part there is no evidence. But once you are in the company, it is you who is to explain where they gone, because they were not seen alive thereafter.
No, I do consider that. I don't dispute that. But one extrajudicial has come up. Even if that is there, it is made by one person, not by all.
Not by extrajudicial confession. He stated what we did.
My lord. We means not specifically anybody, my humble source, because all the villagers, because as per all evidence, all see because of this witchcraft, there is a hostility between all the villagers with those persons, my lord. If that is so, my lord, anybody else has committed, and that's why, my lord, taking note of that aspect, the juvenile, my lord, who is a co-convict, who is a co-accused, my lord, he has been acquitted, my lord, from the charge of 302, my lord. And that exactly, my lord, the honorable trial, although juvenile court, while dealing with all such evidence, he has given a clean sheet to the concerned co-accused, and who has also been acquitted. So my humble submission, when the co-accused, who has also stands on the similar footing, who is having the same allegation, he has been acquitted, convicting the appellant with the same charge by another court. How far is justified is required to be considered by my lord.
No, in the trial, as we gathered from that evidence,
my lord,
she did not implicate this boy, the juvenile, in that murder. That is the ground, sir. That's why she was convicted for other offenses, minor offenses. So, ସେଇଥିପାଇଁ ସେ କହୁଛି ଯେ ତାକୁ omit କରିଦେଲା ସେ ତାକୁ ଇଏରେ.
The evidence is one and same, my lord. The same evidence.
Juvenile କାହିଁକି ତାକୁ 302 ରେ acquittal କଲା, the reasoning might be there. We are not concerned with the reasoning. We just wanted that evidence to be confronted. You file the application.
I have heard that.
So that's.
And the juvenile, the same evidence, my lord, that she was there, she was participating, she was doing all sorts of things, and then she has also while they were shifted, he has also shifted, he was also one amongst the persons, with that evidence, when you
Mr. Khan, evidence has been separately recorded.
I do consider.
For the juvenile, it is tried in a different court and a different presiding officer. This evidence is different. Suppose in this case, a PW on the basis of PW1's evidence, one accused would have been acquitted who is similarly, matter would have been different. But that juvenile was tried in a different court. Different evidence was adduced. Assessing that evidence, the court found that 3-0. So
my humble source
merely because he has been acquitted.
No, I am not. My humble source also. The state has also not come forward challenging that, It has also confirmed the moment things was there. So the state has also not come forward challenging that, So now
that is up to the state what they did, because the appeal is perhaps there, pending in the juvenile against appeal ବୋଧେ ସେଇଠି
ଅଛି ସେଠି pending ଅଛି pending ଅଛି
so and in case
enhancement has not been filed.
No, we are not. So all right, so
and the entirety based upon the evidence of PW1, and the delay and the possible the existence of the cow set. So all these things, and the delay part.
That 10 days period, we have fixed it on 3rd, na? 3 तारीख honors before 3rd. Honors before 3rd रे आपण order copy 3 जा दे दियो जो Mr. Chand को दियो एक आपको ऑन कर दियो जो
one submission, my lord, one submission to the reply of the Mr. Chan.
सबको ज्वाइन करियो अपन.
So whatever now they submitted before my lord regarding the enmity or previous enmity or the that suggestion has been not been put to the PW1 during cross-examination.
Okay, हमें जो order टा pass करती लो, order टा कौन गला? The order which you passed on 29/2024, Friday. In the last part, we have said, according copy टा देले ना बाहर करियो. Just copy दियो ना तापर तापर. 3 जनों को copy दिए जाओ. 3 टा print out करा दो. Intercept transfer will be zero. So far as state part is concerned, that is in paragraph 4, Mr. Das. And so far as your part is concerned, please come to paragraph number 6. Accordingly, the appellant is allowed to file affidavits. How to copy दियो? Stating therein the mitigating circumstances supported by materials, if any. Furthermore, Superintendent of Prison is directed to comply the above order and submit the reports and such other material for perusal of the court on the date of hearing of the sentence. Affidavits shall be filed by the appellant and reports of the jail authority with all relevant materials shall reach this court within 10 days or at any time before 3rd of October 2020. So you are getting sufficient
Today,
time.
my lord, 23.
23. You are getting sufficient time. So
ହାର୍ଡ ହବନି ତାହେଲେ ଦିନ ଆଜି 23 10 ହାର୍ଡ ହବନି
ରାୟଗଡ଼ ଟିକେ ଆଉ ଟିକେ ମଣ୍ଡେ ବେଳକୁ
the date has already been
try my lord.
we are we will take up this matter
Because
on
someone go to the place now, the village and to inquire and to come and
obviously.
so today
No, ଆମେ ତାକୁ ସେଦିନ ଆମେ ତାକୁ ଯୋଉ ଆପଣ ନେଇ ଆସିବେ ତା ଭିତରେ
ଆମେ
ହେଲା ଆପଣ କଲେକ୍ଟ କରିଦିଅନ୍ତୁ ସୋ
Friday or Saturday.
Mr. We are keeping it on 7th ହେଲା 7th ରେ ରଖିବା ଆପଣ we are taking up this 7th at 10:30 so that
The superintendent is to collect all the reports with the assistant, the local officers,
yes madam
probation officer, doctor, whosoever,
yes madam
and then to submit. So it will not take much time, sir.
and also some of the persons who are the inmates of the jail
ହଁ ସେଟା ଜେଲ କଣ୍ଡକ୍ଟ ବିଷୟରେ
ଆଜ୍ଞା ସେଇଟା ହଁ
ଆପଣଙ୍କର ସିଏ ରହିଗଲେଣି ବର୍ତ୍ତମାନ 8 ବର୍ଷ ହେଲାଣି
8 ବର୍ଷ ହେଇଗଲା
8 ବର୍ଷ
ବହୁତ ହେଇଯିବ sir
ହଁ ସେ ତାଙ୍କର କଣ୍ଡକ୍ଟ କଣ ସେଇ ଯେ ସୁପ୍ରିମ କୋର୍ଟ ଡିସିସନ ରେ
ଆଜ୍ଞା।
ସବୁ କୁହାଯାଇଥିଲା ପ୍ରିଭିୟସ କଣ୍ଡକ୍ଟ ପୋଷ୍ଟ ଏଗୁଡା ସବୁ ଆଣିବେ ଆଉ so we are keeping it on 7. We'll take up this matter at 10:30 so that on that day both of you will get full opportunity to address on the question of sentence. You can cite the decision. We will verify this our affidavit Mr. Chand jaha kariba katha so ତାଙ୍କୁ ଆମେ ଜଣେଇ ଦଉଛୁ ଆପଣ ବି କଥାବାର୍ତ୍ତା ହେଇଯିବେ ଆମେ ଯାହା କହୁଛୁ ଆପଣ ମାନଙ୍କୁ ଶୁଭୁଛି
Subhati, sir.
ହଁ 20/9/2024 ରେ ଆମେ ଗୋଟେ ଅର୍ଡର କରିଥିଲୁ ଆପଣଙ୍କର ଆଡଭୋକେଟ୍ସ ମାନଙ୍କୁ ମଧ୍ୟ ତାର କପି ଦିଆ ହେଇଯାଇଛି ସେ ଅର୍ଡର ଅନୁଯାୟୀ ଯୋଉ ଅନରେବଲ ସୁପ୍ରିମ କୋର୍ଟଙ୍କର ଡାଇରେକ୍ସନ ଅନୁଯାୟୀ କେତେ ଗୁଡାକ ଇନଫର୍ମେସନ ଆମେ ସେ ବିଷୟରେ ଆଣିବୁ ଯେ ଏମାନଙ୍କର ଏ ଘଟଣା ପୂର୍ବରୁ ସେମାନଙ୍କର ତାଙ୍କର କେମିତି ତାଙ୍କର ଆଚରଣ ଥିଲା ତାଙ୍କର ଜେଲରେ ରହିବା ପରେ ତାଙ୍କର କୋଉ ଭଳି ସେମାନେ ବ୍ୟବହାର କରୁଛନ୍ତି ତାଙ୍କର ମାନସିକ ସ୍ଥିତି ଆଉ ପାରିପାର୍ଶ୍ୱିକ ଅବସ୍ଥା ଏଇ ସବୁ ବିଷୟରେ ତାଙ୍କର ଆମେ ରିପୋର୍ଟଟି ଆଣୁଛୁ ଆଉ ତା ଛଡା ଏଇ ଯୋଉ ଫାଶୀ ଦଣ୍ଡାଦେଶ ବିଷୟରେ ଯଦି କିଛି ଆପଣ ଆଫିଡେଭିଟ ଦେବାକୁ ଚାହିଁବେ ସତ୍ୟ ପାଠରେ ହିସାବରେ ସେ ବିଷୟରେ ମଧ୍ୟ ଆପଣ 3 ତାରିଖ ଭିତରେ ଆକୁ ଦବାକୁ ଆମେ ସେ ଅର୍ଡରଟି କରିଥିଲୁ ତେଣୁ ଆପଣ ସେ ବିଷୟରେ ଯାହା ଦବା କଥା ଆପଣଙ୍କ ଆଡଭୋକେଟ ଜରିଆରେ ଦେବେ यार परवर्ती शुणाणी 7 तारिख दिन रहिला तो मेरिट रे आपनकर केस शुणाणी हे गला बाकी ए जो डेथ सेंटेंस विषय रे जो शुणाणी 7 तारिख दिन 10:30 रे ही हबो तेणु ए अनुଯାयी धार्य होला अपन से विषय रे टिके बुझेई दियंतु समस्त को हला एडवोकेट जे अछंती प्रेजेंट रहिसंती तांग बुझेई दियंतु हला हां तो आज किए कौन देले रिटिंग नोट ऑफ आर्गुमेंट किए देले
रिटन नोट ऑफ गत थर देइला ए सब नोट्स ऑफ साइटेशन अलग विथ हिज
अच्छा
रिटन नोट
जस्ट अ मिनट टेक डाउन हार्ड Mr. Arupananda Das, learned and additional government advocate. Mr. Himanshu Bhushan Das, learned counsel for the condemned prisoners in DSREF number 1 of 2021. Mr. Manas Chand for the appellants in CRLA number 750 of 2021. The Land Council for the condemned prisoners, Mr. Das, filed memo of citation,
Memo citation, written statement.
written note of submission,
Yeah,
along with the heading that memo of citations. Memo of citation collection
ବର୍ତ୍ତମାନଟା ଦେଇଛି memo of citation, ଗତ ଥରକ ଦେଇଥିଲି
ମାନେ ସେଇଟା ଲେଖା ହେଇ ଆଜି ଯୋଉଟା ଥିଲା
memo of citation ଆଲୋକ
memo of citations which is taken on record, and the Land Council for the state has also filed the memo of citation which is taken on record. The copy of the order passed on 29/2024 has already been handed over to the Land Council for the state. So also the Land Council for the condemned prisoners oblique appellants. The appellants were also apprised by this court about the order passed on 29/2024, and they were informed that they are at liberty to file affidavits in terms of the order dated 29/2024. On consensus of all the Land Council, the matter will be stayed on 7th October 2024 will be taken up at 10:30 a.m. The Land Council for the Swanso will address this court on the point of death sentence. So also file their respective written note of submission, oblique citations, if any. Okay.